I'm late. Delivery of order, item 51 from supplementary list.
For reasons mentioned in the judgment, the proceedings of PRC case number 674/2025 is quashed.
Wait, Look, I have filed an application for bill number 483. May I pray that matter will be listed on day after tomorrow, based on Monday.
Day after, Monday,
Monday.
okay.
Obliged.
Wait, please, Your Lordship. I pray before Lordship, item of 40 minor. Can you take another 2 minor? 3 times matter, I'm concerned from other side also. I'm taken up at 2
No,
minor.
you have to take consent of all those who are listed before you in the list.
Sorry. Well, at 2 minor. This is also, I at 2 minor.
No. We'll try, what is the matter?
Matter, AB matter, my lord. Interim is not there, my lord. CD is there, my lord. So taken about 3 times, well, matter is not reached, my lord. So I am praying before.
No. We'll take it up serially.
May I please allow?
Yes.
Item number.
We'll try to take it up today.
Take it today, my lord.
Today.
Much.
May I please allow? I beg to mention item number 4. Some typographical mistakes are there in respect of dates. I may kindly be allowed to rectify the same.
You file the corrected
Okay.
petition.
Obliged.
Heard. Item number 4, heard Mr. J.P. Das, learned counsel for the petitioner, who submits that some typographical mistakes have crept in the criminal petition and therefore prays for allowing the petitioner to file an rectified criminal petition. The prayer is allowed.
Hello, brother. Hello.
Lordship, this bail application will be listed on Monday, Lordship, 17th. I have already filed it on 11/11, last Tuesday, but till date it is not listed.
Okay.
May I appeal, sir, I beg to mention for listing one, I for suspension of sentence. 7 years conviction will petitioner almost behind bar 2 years. On
When-
Monday, will
When have you filed? Monday, suppose it does not get it.
I mean, we will try our luck.
Okay.
May I please, Lordship? I beg to mention item number 38, Lordship. 38. CD is not there, Lordship. I am on interim, Lordship.
38 case diary is not there. Heard Miss,
M.
what is your name?
M. Deca.
Ndeka, learned counsel for the petitioner. Also heard Mr. P. Thakur, learned additional public prosecutor, who prays for some more time for production of the case diary. Prayer is allowed. Let this matter be listed on 8th of December. The interim order shall continue till next day.
Yes, Lordship.
Lordship, I have to mention IA criminal number 959, public 2025, last date on fixed 8 September. For call for TCR. TCR has come, but the matter has not listing. Kindly may fixed any date.
In the last week of November on a date to be fixed by registry. Yes,
Next week.
yes.
Lordship, prayer for listing of a BA. The accused is behind the bar for 836 days. On 3 occasions, the matter did not reach. Yesterday also matter did not reach, Your Lordship. The TCR is also there and objection is also being filed. Can it be, Lordship, listed before Thursday? Because the arguing counsel will be out of station for a week. Any time on Wednesday also.
Okay, witness.
On behalf of MM on the Lordship, I beg to mention item 21. There's some personal problem, Lordship. Let the matter be listed on next Friday. For the consent of other side.
Item 30,
Item 21.
heard Mr. A. Rana,
M. Rana.
M. Rana, learned counsel for the petitioner, who prays for an adjournment on the ground of the personal difficulty of the conducting counsel for the petitioner. He submits that he has informed the learned counsel for respondent regarding his prayer for adjournment, who does not have any objection to his prayer. The prayer is allowed. Let this matter be listed on a date to be fixed by registry. No, registry shall fix the date.
I take to mention for listing Lordship, IA Lordship, in criminal revision petition Lordship, relay contestation petition Lordship. Next week maybe Lordship.
Okay, next week.
May I please, my lord? My lord, I beg to mention item number 24 matter. Matter may adjourn matter.
20,
4.
24. Heard Mr. K. M. Hassan. You have informed the other side.
Yes, ma'am.
K. M. Hassan, learned counsel for the petitioner, who prays for an adjournment. He submits that he has informed the learned counsel for the respondent regarding his prayer for adjournment, who does not have any objection to same. Hence the prayer is allowed.
My lord, a date may fix, my lord, any date matter.
Let the matter be listed on a date to be fixed by registry. Registry will fix the date.
My lordship.
May I
Obliged.
like to mention for listing of a criminal revision petition on Wednesday or Thursday for orders, Your Honor.
Okay,
May it please your lordship, I beg to mention 30 urgent listing of two bail applications.
when have you filed?
13/11,
Yesterday, Tuesday.
Mentioning for listing a criminal petition on 18th.
When have you filed?
Okay, it was last listed on 16/10.
16th. Next week on a date to be fixed by registry.
May I please, lordship? Item number 54 lordship, supplemental list, 54 lordship. I am for the 15 lordship. Today I have filed Okalatnama lordship. Any other date?
You have informed the other side.
And for the petitioner, actually it was a quarrel between mother of sister and the son, so stay is there, so lordship may extend the interim.
And Mr. S. M. Abdullah P. learned counsel for the petitioner. Also, Mr. What is your name?
A.S. Ali.
A.S. Ali, who submits that he is appearing for the victim in this case and has filed his wakalatnama today and prays for an adjournment. Learned counsel for the petitioner does not raise any objection to the same. The prayer is allowed. Let this matter be listed on a date to be fixed by registry. The interim order shall continue till next day.
Till the next date of listing, man. Oblige your lord.
Please, your lordship. Listing of a criminal petition next week, any day, madam.
When have you filed?
This is all matter, my lord. They are staying there, my lord.
Okay. Okay.
Any day, my lord. Can be on
The
Thursday.
registry will fix the date.
Obliged.
May it please your lordship. Your lordship, I beg to mention an urgent listing of my matter, your lordship.
What matter?
Your lordship, criminal petition 709 of 2018, your
When have you filed?
Your honor, I beg to mention, I beg for it to be mentioned, listed on 19th, your honor.
When have you filed?
Your honor, we have taken it up with the registry couple of times, couple of weeks ago, your honor.
When have you filed that?
Your honor, filing date 14/11/2025.
Okay. Today itself,
Yes, your lord.
registry will list it as in the next week on a date to be fixed by registry.
Your lordship, actually, as per the last order.
No, you cannot file the petition and rush for mentioning.
Your lordship, we have taken it up before the registry, your lordship.
You have filed it today itself.
No, the petition that I have before your lordship is for today, your lordship. I don't have the exact date with me that on which I have filed it before the registry.
You find it out, then mention.
May it please your lordship. I beg to mention listing of this criminal appeal, which has been pending since 2019. So, let it come in the next week.
Pray before registry.
Obliged.
May I please your lordship. Lordship, I beg to mention item number 2, your lordship. When Mr. A. Ganguly is out of station, your lordship, that will fix anything, any next week, your lordship.
Heard Mr.
Each it.
P. Chetri, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
Much obliged.
May I please your lordship, lordship, I beg to mention for listing an IA lordship. Any date will be given in next week, lordship. The matter is pending since 2022, lordship. The last date was fixed on 11/9. The matter was not listed before the honorable court.
Okay, next week.
Next week, any date, lordship.
Date will be fixed by registry.
Obliged.
May I please your lordship. Prayer for listing criminal petition. We have challenged the
When have you filed?
file 4/2/2025. 4 to
What was the last order?
5/9/2025. 5/9/2025.
Oh,
Last question.
what was the last order regarding next date?
Date not given.
Pray before registry. Pray before registry.
I already filed the petition from the registry, but the result has not served. So we are for listening to the.
Next week on a date to be fixed by registry.
May I please, your lordship? Lordship, I beg to mention criminal review and petition number 470 of 2025, in which delay is condoned by the condoned on 3rd of November.
But it is not listed.
Yes, it is not listed, and your petitioner is already in jail behind the bar
Next
in
week,
October.
next week.
If possible, then if Monday is.
No fixed date. Registration.
Please, your lordship, I beg to mention item number 9. The two sir is out of station for some urgent work, so any date next week, lordship.
Heard Miss L.
In Lu. on behalf of the
Tinglu,
police.
learned counsel for the petitioner, who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
Obliged, lordship.
Please, your lordship. Delhi list number, item number 22. It is required to be preponed and urgent hearing is required since the matter has not been come before you lordship till 10 April up to 25.
Item number 22 is in the list today.
Yeah.
We'll take it up when the matter is.
But not becoming the hearing because the Learned Trial Court has given tomorrow is the fixed date for our hearing argument. They are very much reluctant to give time and in the meantime, no stay order has been given by your lordship, and in this matter, it is required urgent hearing for this case, so as enable us to appear before
We'll take it up at 4 p.m.
4 p.m.
Yes. Yes, next mentioning.
My pleasure, Lord. So I beg to mention item number 11, madam. I'm paying for adjournment for the development in this matter, and matter maybe come up on next week. Motion, madam.
Heard Mr. A.K. Azad, learned counsel for the petitioner, who seeks an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed next week on a date to be fixed by registry.
Lordship, with the consent of the other side, I beg to mention item number 20 for adjournment.
24,
20.
what is your name?
S. Borhuya, on behalf of R. Borhuya.
Heard Mr. S. Majumdar,
S. Borhuya.
S. Borbhoya, learned counsel for the petitioner, who seeks an adjournment on the ground of personal difficulty of the conducting counsel.
Interim
Yes.
is there,
for the,
petitioner.
he
Interim is-
he submits that he has informed learned counsel for the respondent regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed on a date to be fixed by registry after a week.
Lordship interim order.
The
is there.
interim order shall continue till next day.
May it please, your Lordship. Lordship, I beg to mention item number 36, Lordship. Earlier, 2 times CD was called for, Lordship. It
What
was-
is, what is your prayer?
Lordship, a reminder may be issued and next date may be fixed. Item 36.
Case diary is there.
Today's, no, Lordship, he had not received, Lordship. Today's third time, Lordship. From it is.
What is your name?
R Islam, Lordship.
Heard Mr. R. Islam, learned counsel for the petitioner. Also heard Mr. P. Thakur, learned additional public prosecutor, who prays for some more time for production of the case diary. Prayer is allowed. Okay,
36 case there notice.
prayer is allowed. Let this case be listed on 28th of November.
Apply.
When have you filed? Yes,
Your Lordship, I filed it on 25th June 2025. Before the registry.
okay, on Monday.
Your Lordship, it may be listed on 19th, Your Lordship.
Okay, 19.
Item number 1.
Previous bail application earlier petitioners approached Lordship and Lordship out of total 23 accused persons Lordship, 18 were granted by this court Lordship bail and 5 was rejected Lordship. Now Lordship subsequent development taken place, charge sheet has been submitted and case is fixed, someone issued and fixed on 12th of December Lordship.
What is the offense?
Lordship. Lordship, under section 191, 190, 329.
If summons have issued, you appear before the trial
Lordship,
court.
only I need some protection, Lordship.
What protection?
Lordship, since charge sheet has been submitted declaring me absconder, Lordship.
No,
once I
that may not
appear-
be reason for rejection of bail. If you pray before the trial court,
Lordship, I will appear, Lordship, some protection may be given. Lordship, in the similar circumstances, Lordship, declaring the accused petitioner absconder and court has granted protection, Lordship.
no.
I'm
You appear before the trial
just
court.
drawing the attention, Lordship. That I can do.
Is there any bar on the part of the trial court to grant you bail?
Lordship, the case
No, apprehension does not have any basis. Is there any bar?
is no bar, Lordship, but the court is bench, Lordship.
If there is no bar, I'll make observations to that effect. You appear before the trial court.
But Lordship, the order I have.
What is the offense?
Since Lordship.
4 persons
Yes.
grievously injured.
Injured.
Earlier,
There is a land dispute,
What is the maximum punishment?
Lordship, 10 years, Lordship.
10 years. There is no bar. The court can grant you bail. That observation I will make.
Usually, Lordship, once when they
No, no.
declared absconder and appeared, they send in judicial custody.
That,
Only by
that may not be a ground for seeking anticipatory bail. Heard Mr. S.U. Amen, learned counsel for the petitioner. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely petitioners, namely 1, 2, 3, 4, 5, who are apprehending that they may be arrested and who are apprehending that they may be remanded to custody in connection with PRC case number 342/2025 arising out of Sukhchar PS case number 26/2025 under section 191 within bracket 2/191 within bracket 3/190/329 within bracket 4/329 within bracket 3/118 within bracket 2/117 within bracket 2/109 of BNS. You have gone through the provisions. What is the maximum punishment?
This is lordship.
For no offense, punishment is more than 10 years.
Is there lordship?
Yes, Mr. Bhattakar. Is there any offense involved which entails more than 10 years? No,
10 years, madam.
maximum is 10 years.
10 years.
Stop. Learned counsel for the petitioner has submitted that since charge sheet has been laid in the aforesaid PRC case.
Regarding submission of search sheet, I have no instruction, but his instruction is that.
No, that is his submission.
Yes.
PRC case. Since charge sheet has been laid in PRC case number 342/2025, showing the petitioners as absconder therein, comma, the petitioners apprehends that on their appearance before the trial court, they may be remanded to custody. Stop. On the other hand, learned additional public prosecutor submits that you have received summons.
Lordship, someone issued, I have not received lordship. Page 51, date is fixed on 26 December, lordship. Page 51, I have enclosed the order of the trial court, lordship. Page 51.
Since summons have already been issued by the trial court,
See 26.
there is no apprehension of petitioners getting arrested in this case. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. Since the offences under which charge sheet has been laid against the present petitioners does not entail punishment of imprisonment more than 10 years. Hence, there is no embargo on the part of the court which has issued summons to grant bail to the petitioners. Stop. Even though the petitioners' names have been shown in the column as in the charge sheet as absconders. However, since the trial court has issued only summons to them, there is no apprehension of the petitioners getting arrested, as no coercive processes have been issued against the present petitioners. This court is of considered opinion that if petitioners appears before the trial court and prays for bail before the said court, the trial court is competent enough to consider and to grant bail to the petitioner if it deems it fit to do so. Therefore, this court is of opinion that there is no apprehension of the petitioners getting arrested in this case as of now. Accordingly, the petitioners are directed to appear before the trial court and pray for regular bail on their appearance before the trial court, if so advised. This anticipatory bail is accordingly disposed.
May I please?
Yes.
My lord, it's a pre-arrest bail application. Petitioner is a lady having a small child, my lord, lactating child, my lord, of 7 months.
7 months.
7 months. And my lord, she was a branch manager of SBI at Tinsukia, my lord. Then she lost an FIR, my lord, page 26, my lord.
Who the petitioner lost an FIR?
Yes, yes, she first lost an FIR, my lord, page start from page 26, my lord. That some anomalies is going on while granting, my lord. Page 28 is the effective part, my lord. Relevant portion that some
doubtful transaction while loan disbursement is going on, and that has been registered, my lord. It Bijguri Police Station, my lord. As Tunchikia Police Case number 46/24. Thereafter, my lord, what happened? The authorities also lost 2 FIRs, my lord. That the first FIR lordship will find for the same cause of action, page 43. Page 43. Where I have been also been summoned, and accordingly I applied for anticipatory bail, and page 50 is the bail order. Page 50 is the bail order, where detail has been reflected. Considering the nature of the offense and the documentary evidence and her role, because she was not the field officer, my lord. She has to base, on the basis of the report of the field officer, she has sanctioned one particular loan, my lord. She has.
Okay.
So she was granted. Page 52, my lord, paragraph 5, lordship can peruse it. 4 also, my lord. The learned counsel for the petitioner has drawn the attention of this court that the allegation that the loan was proceeded by Sri Satyendra Kumar Pathak, who was the field officer, and then the present petitioner is alleged to have sanctioned the loan. It is submitted that the sanction authority relies upon the report of the field officer, and the present petitioner was innocent. There was no malafide and deceitful sanction and a personal loan a higher amount to the borrower. Annexure D submitted that in support of the petition, stating that the pre-sanction appraisal, assessment and recommendation requires that the official was scrutinize the proposal, credit report and recommendation to the sanctioning authority shall ensure that the strengths and the weaknesses of the proposal have been brought out clearly to ensure the proposal to be put up to the sanctioning authority as per the law laid down and rules, regulation, loan policy of the bank. So accordingly, my lord, absolute bail was granted to her, my lord. So there's one more FIR, now page 78, where petitioner is now before your lordship. Similar allegation, my lord, there's one more loan, 2 more loan, my lord, sanctioned during the time of the petitioner. Here also, the same person, the field officer, against him, my lord, all the allegation that he has verified the loan document.
His seal and sign.
And he has sealed and signed, under his seal and sign, it has been
Where is the FIR?
page 78, my lord.
The 80 is the relevant part.
Yes, yes. 80 is the 11 part.
ठीक है ऐसे.
That the perusal of the original, my last paragraph in the page 80, perusal of the original system generated consolidated consumer credit report and the consolidated consumer credit report available with the aforesaid loan document, sealed and signed by the deed and field officer Satyendra Kumar Pathak, following the discrepancy are found. So these are the discrepancy. It is important to mention herein, the aforesaid borrower has already availed the housing loan of 8.6 lakhs from Dhemaji branch, having installment of so-and-so amount, housing loan from Dhemaji branch so-and-so, so-and-so. So basically, he has availed 2 loans from another bank, and then he has applied the same loan from this bank also, my lord. So again, my lord, lordship will find page 82, Roman 2, my lord. The express
The accusation mainly is against the
field officer.
field officer as well. Your name is Bokshika.
Yes. I have sanctioned the loan, madam, on the basis of the report. And I am the first who has lost the first FIR, madam.
Okay,
Then, madam,
yes, Mr.
Yes, my lord, here, earlier, my lord, yes, there are three cases, my lord. Initially, in earlier two cases, my lord, the petitioner obtained bail, my lord. This is third case regarding allegation is, my lord, forgery of sanctioning loan. At that point of time, my lord, present petitioner was the branch manager of that branch, my lord. And initially, yes, on 27 to the first, my lord, the present petitioner has lodged an FIR, my lord. And thereafter, my lord, on the next day itself, her higher authority has lodged one another FIR, and on the basis of that FIR, he.
But the present FIR is lodged on 29/8.
29. Before that, on 27, my lord,
The petitioner herself,
yes, 27 to 24, the
Yes.
first, my lord, the present
that
petitioner.
is
has
7 month.
8 months.
Prior,
yes,
Prior.
I have prior, my lord. These FIRs after 8 months.
And
let her appear.
thereafter, my lord, she was suspended, and my lord,
She is under suspension.
yes.
And that has been revoked, my lord. Now, my lord, and she has been shifted to another branch that I have also mentioned, my lord.
Assistant manager, regional business.
With a minor penalty, my lord, she has been again reinstated, my lord, after the DP, my lord.
Okay,
And my lord, one point I would like to submit that this is not the same, my lord, although offences are similar, but three different and distinct offences, all those loans were sanctioned to three different individuals, so not the same cause of action. Three separate cause of action.
who availed the loan in this case?
In this case, my lord, 678,
2%, my lord. Manju Gogoi. And Roman 2, my lord, page 82, Dipti Chuti Sattradhar.
So. Heard Mr. A. M. Bora, learned senior counsel assisted by Mr. V. A. Chaudhary, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by
Regional manager, my lord.
one Srimati Ms. Bokshika Negi, who is apprehending her arrest in connection with Tinsukia PS case number 347/2024 under section 120B/420/468/471 of Indian Penal Code. The gist of accusation in this case is that on 23/9/2024, the regional manager, regional business office, State Bank of India, Tinsukia, had lodged an FIR before the officer in charge of Tinsukia police station, inter alia, alleging that it has come to the notice of the authorities that some loans have been sanctioned by the Tinsukia branch of which State Bank of India,
My lord.
State Bank of India fraudulently by forging relevant documents. It is alleged that the field officer Satyendra Kumar Pathak and the present petitioner, who was acting as branch manager of the said bank, in connivance with the borrowers, manipulated the consolidated customer credit reports and sanctioned a loan of rupees 12,80,000 to the borrower. It is alleged in the affair earlier also the said borrower took different loans from Dhemaji branch of the State Bank of India. Stop. Learned senior counsel for the petitioner submits that the petitioner was employed as the branch manager of State Bank of India, Tinsukia branch. Tinsukia branch or Hijuguri branch?
Sizuguri branch, Tinsukia.
Hijuguri branch, Tinsukia. And in the month of February, she noticed some anomalies in grant of loan, in availing of loan by some of the customers, by suspected to be using fake documents, and accordingly an FIR was lodged by the present petitioner to that effect on when the FIR was lodged by you
27/2/24,
on
my lord.
27/2/2024, and on the basis of the said FIR, Tinsukia PS case number 46/2024 was registered. Thereafter, on 7/5/2024, the bank authorities lodged an FIR alleging anomalies in grant of loan, wherein name of the present petitioner was also mentioned. On this, the petitioner approached this court by filing an anticipatory bail, and accordingly, in AB case number 1446/2024, by order dated 14/6/2024, the petitioner was granted anticipatory bail. Learned counsel for the petitioners, senior counsel for the petitioner has submitted that it was the petitioner who alarmed the authorities by filing the FIR at the first instance way back in the month of February 2024. He further submits that in a similar case, where the petitioner has been granted anticipatory bail, she has been cooperating in the investigation. He also submits that being branch manager, the loan was sanctioned by the present petitioner on the basis of the report of the field officer. And therefore, there was no intention to defraud or commit any offense by the present petitioner. He further submits that the present petitioner is a lady and a mother of a 7-month-old,
7 months old.
7-month-old baby, and she is ready to operate in the investigation. He further submits that though the petitioner was also suspended by the bank authority initially, however, she has been reinstated and has been transferred to
Regional Business Office, Bordoloi Nagar, Tinsukia.
to the regional business office of the bank at Tinsukia. On the other hand, learned additional public prosecutor prays for calling of the case then and submits that this case is a different case from that of the case in which she was earlier granted bail,
Economic
Yeah.
offense.
and therefore it has to be examined on its own merit. Call for the case, Sari. Let this matter be listed when 16th of December. Stop. In the meanwhile, considering the submissions made by learned senior counsel as discussed in the foregoing paragraphs, the petitioner is directed to appear before the investigating officer of Tinsukia PS case number 347/2024 within 7 days from the date of this order and cooperate in the investigation. If she does so within the stipulated period of time, in the event of her arrest in connection with the aforesaid case, she shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, 1 and 2, list accordingly.
Oblige.
In this case, my lord. In this case, my lord, the petitioner challenged the order dated 29/7/2025, passing petition number 112825. My lordship, what happened, my lord? I am not on for the main case, my lord. I am only on this particular senior application. Kindly turn to page 22. Page 22 of section 2. This application has been filed under section 311 of CRPC, read it section 138 of the Indian Evidence Act. What happened, my lord? There is a list, lordship will find the list, lordship. In the page 25, we have submitted before the court that this person should be made as as a court witness during the course of the evidence stage, my lord, or any stage, my lord. But court has refused it. Why, my lord?
You adduce them as your own witness.
Defense we can adduce, my lord. From serial number 1 to 6, we can adduce, my lord. We can make the request. They may come, they may not come. But 7 and 8, my lord, these are not my inmates, my lord. They are not my colleague. They are the shopkeeper, my lord. This is the soap. The entire cause of action arose from that soap, my lord. What happened, my lord? Why it is required, my lord?
No, you can still make them defense witness. Ask the court for summoning them.
We have ample time, but that is why it is required, my lord. Please take it.
At what stage the case is pending now?
No pendency is required. Only 2 persons may be adduced as the.
No. It is a 138 Negotiable Instrument Act case. NI Act case.
No, POSCO.
Criminal
POSCO case, my lord.
Oh, sorry.
It's the POSCO case, my lord.
POXO case at what stage?
As per evidence, the defense thing is going to be started. Already, my lord, prosecution is with evidence has been closed.
You have been examined under 313 corresponding section 2.
No, I am not.
After closure of prosecution witnesses,
Now the defense witness is going to be started now.
You want three statement about children.
Accused. Oh, yeah, that has been done, my lord.
So
My pair is that, my lord, some list that some person is required to be summoned as a witness, my lord. Because
defense witness,
Hmm?
as defense,
Neutral, my lord. As defense or neutral, if
what is meant by neutral witness?
actually what happened, court witness, my lord, 160,
No, you want them for the purpose of your defense.
yes, ma'am.
Then they are defense witness. If you want them to be summoned by the court, court will issue summons to them.
Yes, that is, my contention is that, my lord, they are the very vital persons, my lord. Because as per the FIR, my lord, the girls went to their shop. The police has, at the time of the investigation, their statement, neither their statement has been recorded, nor they have been adduced as the witness, my lord, in the search sheet. Therefore, my lord, what the IO stated in her statement, my lord, kindly turn to page 30, my lord. Page 30, my lord. For the time being, my lord, give a look, my lord. That's why it is required, my lord. In the FIR, it is clearly stated the girls went to their shop and they are not the inmates of the accused person and they are not living nearby the place of occurrence. Only the thing is
Where is the impugn order?
impugn order lordship will find at page 26. Page 26, the relevant portion is that in the last paragraph, perusal of the petition reveals that the witnesses which accused wanted this court to examine as court witness were the inmates of the house of the accused where the occurrence had allegedly taken place. It may be pertinent to mention here that the accused is yet to be entered upon his defense. The accused shall have all the right to examine these witnesses in his defense.
Yes, the court has observed it.
Yes, that is an observed, my lord. Inmates, my lord, 1 to 6 are my inmates.
Read, further read. Read the impugn order.
Perusal of the petition reveals that the witnesses which the accused wanted this court to examine as court witness were the inmates of the house of the accused where that occurrence has allegedly taken place. It may be pertinent to mention here that the accused is yet to enter upon his defense. The accused shall have all right to examine these witnesses in his defense. Accordingly, failure to examine the persons mentioned in the petition as court witness is rejected.
Rightly rejected.
My lord, my pair is that, my lord.
Court has not foreclosed you from examining those
Yes, my
witnesses.
lord.
You can examine them as your own witnesses.
My question is that, my lord, 2 persons, they are not inmates. The court says all are the inmates. No, 7 and 8.
No, whosoever you want to examine, you can summons them, you
Why-
can.
why they are required, my lord?
Court has not said that they are not, they shall.
Refuse. But it is not on my part that person, I can make a request to appear there. They may come or they may not.
No, you can ask the court to issue summons to them.
Yes.
Court
Yes.
has not said that it will not issue summons. It will not issue summons to them as court witnesses. As defense witnesses,
As
it-
defense
it-
witnesses, my lord, you can-
they can be recalled by court issuing summons to them. There is no bar. Is there any bar?
there is no-
Court has not
My lord,
closed your options.
it is still open, my lord. I am.
So what is the error in
My
the?
lord, I want to say is that, my lord, let it make it specific that let that 2 last person may come to the court by summoning to adduce their witnesses.
Court has not said anything that you cannot examine. Heard Mr. What is your name?
D. Borua.
Heard Mr. D. Borua, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 438/442 read with section 528 of BNSS has been filed by the petitioner. Petitioner namely Ajay Sakharu alias Shakaru, impugning the order dated 29/7/2025, passed by learned Special Judge Dhemaji in connection with in POXO case number 9/2025, or whereby it has declined to summon it has declined to examine the witnesses, list of which was given by the petitioners in petition number 1128/2025 as court witness. Learned counsel for the petitioner has submitted that the petitioner is facing a trial under section 376 AB/511 of the IPC, read with section 4 of the POXO Act 2012, before the Court of Learned Special Judge Dhemaji in special POXO case number 9/2024. He submits that in the said case, the prosecution witness has been closed and the petitioner had filed an application before the trial court, which was registered as petition number 1128/2025, wherein he has mentioned a list of, he has mentioned the names of 8 witnesses who are relevant for the defense of the petitioner and who were present. Why they are relevant? Yes, why they are relevant? How the witnesses?
Serial number 7 and 8, there is a shopkeeper, my lord, where the girl in the affair mentioned that the girls went to a shop, and while she has come back from the shop, the incident has taken place.
Stop.
There is a shopkeeper, my lord.
Hello.
The shop that is in question, my lord.
Stop. The petition, learned counsel for the petitioner had struck. Learned counsel for the petitioner submits that the petitioner is in no way involved in the offense alleged in this offense, in the case, and he does not have any knowledge that his vehicle was used for commission of offense alleged in this case. He further submits that even the apprehended accused within bracket driver has not named the owner, and there is no complicity of the present petitioner in the alleged offense in any manner. However, his vehicle is lying in the where police station? In the Kotkoti police station for last 7 months.
From February.
For last 9 months. He further submits that this court directed the prosecution side to obtain report from the report concerning where Jimma of the seized vehicle from the investigating officer way back in the month of May 2025. However, till date, the prosecution side is unable to produce, has been unable to produce the said report. On the other hand, learned additional public prosecutor has sought for one last chance to take instructions as to whether the petitioner is in any way involved in the offense alleged in this case, and whether he has been named as an accused in this case or not. Stop. The prayer is allowed. The if the learned additional public prosecutor fails to get a written report, he may seek the necessary instruction over mobile phone from the concerned investigating officer. Let this case be listed Wednesday. 19. Let this case be listed on the.
Much obliged, your lordship, much obliged.
May I please? Okay, here in this case, Kesari was called for my. The petitioner seeking Zimmer of some cash amount and.
Is there is there?
Okay, the matter, I have received one intimation regarding filing of charge sheet. In this case, charge sheet submitted by CS number 46125 dated 27.
Why it was rejected?
My lord. Page number 32, my lord, impugn order, my lord, 32.
Who are you? Owner?
I am Fazor Ali, my lord. I am a jailer by profession, my lord. I have jewelry shop, my lord. From there, some gold ornaments along with that rupees 2,50,000.
You are seeking Jimma of the ornaments.
Ornaments as well as cash rupees 2,50,000.
What is the acquisition?
My lord, kindly page number 11, my lord. May I read, my lord?
No, you tell me the what.
My lord, acquisition is the some cash amount along with gold ornaments were stolen by some unknown person, my lord. This
And
is the
same was recovered from your possession.
My lord,
You are the accused.
I am also an accused, my lord. Kindly for a moment, my lord, page number 12.
Case diary would be required.
Yes. I will get that.
Heard Mr.
No, my lord, charge sheet already submitted, so scan copy.
Then scan copy of.
Heard Mr. A. Parmani, London, counsel for the petitioner. Also heard Mr. P. Bothakur, London, additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number. Charge sheet is number is there.
Yes, 461/25 dated 27/10/25.
Stop. In view of above, let the scanned copy of the charge sheet and the connected case diary be called for from the trial court. That is the Court of London, Chief Judicial Magistrate, Kamrup Metro. The registry to take steps for requisitioning the scanned copy. Let this case be listed again on 25th of November.
Ali.
Lordship, may I peruse order dated 26/9/25. Lordship was pleased to stay the further proceeding and also was pleased to call for the scan copy. And there is a direction to list the matter along with an analogous matter, which is referred in the book. That particular case has not been listed. Lordship will find the order 26/9/25, second page of it. Along with criminal petition number 746.
Scan copy has come.
No, my lord, scan copy not yet received.
Heard Mr. Zaid Alam, learned counsel for the petitioner. Also heard Mr. P. Bothakur, learned additional public prosecutor. It appears from office note dated 12/11/2025 that the scanned copy of the trial court records along with the scanned copy of the connected case diary have not yet been received. Issue reminder for the same. It also appears that by order dated 26/9/2025, This case was directed to be listed along with criminal petition number 746/2025. However, same has not been done. Registry to comply with the order. List this matter again after 2 weeks on a date to be fixed by registry. The interim order shall continue till the
No, sir. Not.
May I please, Your Lord? My Lord, 528 application, my lord, seeking quashing of the FIR and subsequent charge sheet, my lord. My lord, the FIR is at page 18, my lord.
What is the stage?
The appearance, my lord. So the charge sheet was filed
When is the date?
24th of December.
We'll call for the case diary and what is the ground?
My lord, even if the FIR is taken in its entirety, it does not make out any offense having been committed by me.
And in the charge sheet?
Even in the charge sheet,
Even in the charge sheet?
even in the charge sheet. It's a civil case, purely civil case. I had taken on rent on lease some scaffolding materials from the complainant.
Okay. Heard Mr. B. Prasad, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner Shri Manas Bortamuli, praying for quashing of the FIR and charge sheet lodged in connection with Sangsari PS case number 10/2025. On the basis of which PRC case number 313/2025 has been registered. The main contention of the petitioner in this case, of the learned counsel for the petitioner in this case, is that even if the
Allegations.
even if
Allegations
the allegations made in the FIR
taken in its
are taken in its entirety, as well as materials collected during investigation are considered, it does not makes out a criminal offense. He submits that the dispute involved in this case is entirely purely of civil nature. Stop. Issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by speed post within 7 days from the date of this order, returnable on 15th of December 2025. Let the scanned copy of the records of PRC case number 313/2025 as well as scanned copy of the connected case diary be called for from the trial court. List accordingly.
It is the court of the CJM, Kamrup at Amingaon.
Trial court within bracket court of learned chief judicial magistrates. Kamrup at Amingaon.
If in the interim, if the further proceeding may be taken.
No, we are fixing it prior to that date,
15th.
15 December. Matthew, next.
May, we were lot of paying for the warrant of arrest issued by the learned sessions are taking the petitioner. Petitioner were absent, several days was absent, and the petitioner minor. Learned sessions are issued NBW.
Why you remained absent?
My lordship, kindly see the order dated 7/1/2025, my lord, page 30, my lord. Earlier, you were. I'll finish, my lord. Operative portion, my lord. Page 32, my lord.
Page 30,
30.
page 30.
32, my lord. 32.
Yes.
Last paragraph, my lord. Considering submission made by the learned council for both sides, and also taking into account the conduct of the accused petitioner, I hereby direct the petitioner to appear before the learned trial court on the next date fixed, that is 9/4. 9/4 was the appearance date, my lord, and file a fresh petition for regular bail. Upon filing such petition, the learned court below shall consider and dispose of the same in accordance with the law. Till then, the execution of any NBW issue against the petitioner shall stay / suspended, my lord. On 9/4, my lord, I could not appear because my mother was ill, my lord. Subsequently, my mother died, my lord. That is why I could not appear, my lord. I have annexed my death certificate, my lord, my mother's death certificate.
When your mother died?
Mother died, my lord, 29/8/2025, my lord. I am ready to appear, my lord.
When is the next date fixed?
Next date, my 17/11, my lord.
Yes, Mr. Bhatt.
His mother expired on 29/8/25.
There was a gap of 4 months.
My lord, yes,
But
yes, yes, my lord, long time, my lord.
Okay. Okay. Heard Mr. N. Hawk,
Take care.
sorry, A.K. Azad, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, who is aggrieved with the order dated 14/6/2020, 14/6/2025, passed in special sessions case number 73/2020 by the London Sessions Judge Sri Bhumi, whereby non-bailable warrant of arrest was issued against the present petitioner. Learned counsel for the petitioner has submitted that the petitioner is facing a trial under what provision?
Section 4 of POCSO, my
Facing a trial under section 4 of POCSO Act 2012 in special sessions case number 73/2020 before the Court of London, Special Judge Sri Bhumi. He submits that on an earlier occasion, the trial court had issued non-bailable warrant of arrest against him, and he had approached this court by filing a criminal petition. By agreed with the said order. Stop. On that occasion, by order dated
7/1/20.
7/1/2025, passed in criminal petition number 7/2025, a coordinate bench of this court had directed the petitioner to appear before the trial court on 9/4/2025 and state the execution of operation of any non-bailable warrant of arrest issued against him. Stop. He further submits that on 9/4/2025, the petitioner could not appear before the trial court as the mother of the petitioner was seriously ill. He submits that subsequently on 29/8/2025, the mother of the petitioner expired. When is the next date fixed in this case?
17/11. Monday.
He further submits that the aforesaid case is fixed before the trial court on 17/11/2025. And the petitioner is ready and willing to appear before the trial court and face the trial. However, as non-bailable warrant of arrest is pending against him, he seeks an interim protection. Stop. Considering the facts and circumstances of this case, as well as considering the willingness and undertaking given by the petitioner that he is ready to cooperate in the trial and ready to appear before the trial court on the next date fixed. This criminal petition is disposed of with a direction to the petitioner to appear before the Court of Learned Special Judge Sri Bhumi in special case number 73/2020 on next date fixed, that is on 17/11/2025, to facilitate his appearance before this trial court on the said date. The execution of non-bailable warrant of arrest issued against him shall remain stayed till that date. Upon his appearance before the trial court, he may pray before the said court. He may pray for regular bail before the said court, if so advised. This criminal petition is accordingly disposed.
Hold on. It is 14/6/25. It should be 14/6/24, madam. 14/6/24.
14/6/24.
20.
Then there is a problem.
Madam.
I thought you mentioned it wrongly, 14/6/24. Because the
Ask warrant, my lord, 14/6/24, my lord.
14/6/24.
My lord.
24 condition. Okay,
Hold on.
item number.
Please, your lordship. And this criminal revision petition is filed challenging the order dated 1/9/25 passed by the learned principal judge Delhi Court number 2 at Guwahati. It is a case of maintenance 125, but here, what happened, my lord? There are several proceedings between the same parties, husband and wife, are there. And all these cases are fixed at the initial stage because of the prayer of the respondent wife. In this case, she was the petitioner in the case, but now here I'm challenged. That's why I was responded there. She is the petitioner now. Now, she in the midst of hearing of the assets and liabilities, just she told that I have to correct the affidavit, my affidavit.
Of assets and liability.
I will also that is paid. I will see paid because amicus curiae was present, my lord. I was also there, my lord. Then it is said that some inconsistencies is there, I have to correct it. Then verbally, the learned court allowed it. On the next day, instead of, we did not get a chance to say anything at that time because we thought that yes, some correctness to correct it, okay, it was done. But in fact, afterwards, see on the date, file, instead of corrected affidavit, she filed, the respondent, I should not say she, the respondent filed the, yes, additional affidavit with all new facts and things of a certain liabilities. That we had, and we objected to it, that how it can be. We have given, asked for, we were given chance to give the what's called objection, and we stated all these things. But on 1925, what it was the learned court that time, my lord, petitioner was absent due to on medical ground. Petitioner, that the husband was absent on medical ground. He allowed all that, but next day he will have to come. That is on 1906. That is on 1906. One line. Oh, no, 1 line of order to district. Yes. Oh, 1 line of absence. Yes. Then what happened, my lord? On 1 line, he passed the order. Against that, we are coming before this honorable court on division. Because he had, without considering.
You are impugning the order dated 1/9
25.
or 11/11/25.
Yes. And
1/9. Where is that order?
is that page? 31. One 925. No, that is not the main order is different. Page number 11. Page number 11, my lord. Can I read it, my lord? This one is present. The opposite party is absent with step 5 petition number 929 filed by amicus curiae, Surya Prakash Chitwal, stating that the opposite party is unwell. Considering the illness of the opposite party, he is allowed to appear on the next day. The opposite party is strictly directed to appear personally before this court on the next day. Today, the case is fixed for hearing on petition number 936/24, 1193/24, and 757/24. Heard the petition and also heard the learned advocate Surya Prakash Chitwal, who is amicus curiae of the opposite party. The opposite party filed petition number 1757/24 stated that at the initial stage, the prayer was made by the petitioner to appear before the court on single date as she would not appear on different dates. What happened in this case, madam? There are 4 cases, 4 cases between the parties, and wife filed 3 cases, and while filed 2 cases, 3 cases are 134 afterwards. 2 cases, 12, she left the husband with the child, a girl child, and she has not completed 1 year or so. That time at night, she went with her elder brother to her paternal home, and she stayed there. Therefore, also he rang her, but she did not give her. So many things happened, my lord. Then in the year 2022, my lord, she filed a divorce. And divorce suit we appeared, and we have filed written statements. And in the written statement, your lordship, that because with such a long divorce with 34 paragraphs, we have to give reply. So many contradictory statements are there. And we have given the reply. And then we prayed that these all false and concocted allegations. And with that, I want to file file a written, this statement can be considered as my petition, as I am also claiming as a counterclaim. I am claiming my divorce. The husband also told, and that is accepted, Your Honor. And she was asked to file the written statements. Thereafter also, my lord, I have to inform this honorable court that they came against that order. They came afterwards to the honorable high court challenging that order, but they did not inform the subordinate court, the lower court. They did not inform. And one day, just in the we have written in our petition also that we had the husband just in that his mobile.
Now,
when he was-
what happened on 11/11? That day has lapsed.
11/11, what happened here, Lord? 11/11, my lord, what happened? I have to say. For personal appearance of the opposite party. On that day, your lordship, on that day, your lordship, what? No. Whether your lordship asked me 1925 or
No,
11/11?
on 11/11, what happened?
25. Yes, that order here is not there. Only it is.
What happened on that day?
On that day, your lordship, on that day, just we had to file a medical certificate. Suddenly, your lordship, that he fell down from a bike and he had to go for X-ray and all these things.
So when is the next date fixed?
Huh?
On 11/11, what next date was given?
11/12 is fixed.
Next date.
Yes, 11/12 is fixed. Now, my lord, I have been that they came against that order also. That is also High Court without giving any notice even. That was rejected. That there and the case is pending. And 4 cases. Very recently, the wife filed another case praying for alimony of 1 crore. Alimony. But the cases, there is under section 25 of the Hindu Marriage Act, she claimed alimony. Then against that, your lordship, that we filed objections and all, but it was, they want to go to take the evidence. That also we have challenged, and it will come, my lord. We have challenged because under 25 it is strictly stated, it is apparent, it is so direct that it can be claimed either by the husband or wife, but when it at the time of passing the decree or subsequent thereto, not before that. But she filed. Then we submitted an objection, and in the objection, we have said that that petition kept in abeyance. You keep it abeyance, but it cannot be now. They have stated, but at this stage, the court cannot take it. And we file objection there also. But they fix a date for hearing. That also, that is the thing where all things are going on. That is, and the.
Okay, we are
Why-
issuing notice.
My lord,
We are issuing notice. Heard.
here,
Miss-
that case notice is already issued. In this case.
Ms. K. Deka, learned counsel for the petitioner. This application under section 438 of BNSS, 438/442 of BNSS has been filed by the petitioner. Nayan Basho, impugning the order dated 1/9/2025, whereby the 1/9/2025 passed by the learned Principal Judge, Family Court Number 2, Kamrup Metro, Guwahati, in FC Criminal Case Number 387/2022, whereby the whereby the said court declined to review its earlier order by allowing, whereby it allowed the respondent to rectify the affidavit of assets and liability on oral submission and directed the petitioner to appear in person before the said court on 11/11/2025. Learned counsel for the petitioner has submitted that on 11/11/25, the petitioner could not appear before the trial court due to medical reasons, as he met with an accident on that day, and the next date is fixed on 12/11/2025. Issue notice to the opposite party, keeping the question of maintainability. It appears to be an interlocutory order.
My lord,
So that question of maintainability you have to address. Issue notice to the opposite party. The petitioner shall take steps for issuance of notice
All-
upon the opposite party by speed post. By speed post
my lord,
within 3 days from the date of this order, returnable on 9th of December 2025. Since prima facie, it appears that the question of maintainability of this revision petition, on the count that it appears to be a revision directed against an interlocutory order, is kept open. Let this matter be listed on 9th of December. List accordingly.
কিমান দিছে?
9 to 11.
It will be, whether it will be okay, my lord, if it is taken 11, 12.
12th, next date is fixed. Okay, 12.
My lord, only my prayer, one thing, my lord. Till then, my lord, interim prayer.
No, we are fixing it before the next date fix. Therefore, no interim. Before the next date fix.
So
You
then-
want,
Okay, my lord, then it is before 7, 5. আগতো ন 7. I will see কিবা 5th, my lord.
Okay.
5th, 12th,
5th of December.
5th, 12th. Pass of them.
On next date, you have to address this court on the question of maintainability.
That is so.
May I please, Your Lordship?
Yes.
528 application for quashing of FIR filed in Sultan Bazar.
We have heard one case by mistake, my lord, in the synopsis and in synopsis and in paragraphs 11 or 16 and paragraph 11 at page 6, my lord, there is a type mistake. Whether I want to correct it, my lord, that case we referred here in support of
You
us.
submit the corrected page
Only, my
on the
lord,
next day.
14 SCC 1.
You change that page. Yeah. Learned counsel, Learned counsel for the petitioner submits that some typographical mistake has crept in page number.
Page, my lord, page in the synopsis, my lord.
In the synopsis need not to be corrected.
It is, it should be
No.
2021 to SCC 324. But we have given here, parties' names are okay, my lord.
Only citation is wrong.
Sorry,
No
wrong
issue, no issue. Let it remain,
2000
let it remain wrong. We will see the right citation.
Very sorry to give the disturbance to this honorable court, and I am of that.
Yes.
For crossing of the FIR filed in Palan Bazar PS case number 278, 2025, my lord. My lord, that is at annexure 6, my lord, page 42, my lord.
Watching of FIR,
FIR, my lord. But
it is
prior to-
pending investigation.
Pending investigation, my lord. But prior to that, my lord, may kindly come to annexure 5, my lord, page 40, my lord.
Yes.
This is an order passed on 14/8/2025 by the learned
Page
page 40, my lord, 40.
40.
40, my
Yes.
lord. This is an order passed by the learned Judge Family Court number 2, Kamrup Metro, my lord. In the divorce proceeding pending before the informant and the petitioner, my lord. The petitioner is the husband of the informant, my lord. That is respondent number 2, my lord. By this order, my lord, the learned Family Court has directed the informant to refund the amount of 13 lakhs which she has taken from the petitioner, my lord. Immediately thereafter, my lord, on 28/2025, my lord, this FIR was lodged at before the Palan Bazar police station, my lord. Not this FIR, my lord. Other two cases were also filed before the concerned. One is before the concerned judicial magistrate and one is before the learned additional session judge number 4, my lord. I have annexed all those documents, my lord.
There are other cases pending between same parties
Yes, my lord.
in this court.
Yes.
Some other criminal petition.
No, not criminal petition, my lord. This 14/8 order was challenged by the informant, my lord. Filed CRP number 403/2025, my lord, and filed order dated 27/10/2025. Your lordship has kept the matter as part heard and directed.
You were directed to appear
Yes,
personally.
yes, on 6/11/2023 for next date, my lord. There is
When is the next date fixed?
no next date fixed, my lord, since the matter was earlier.
No, some next date was given.
My lord, I could not find any next date, my lord.
This matter is required to be taken up along with this.
Yes, my lord.
Will,
CRP,
we will, but that is CRP.
is CRP, my lord.
And this is a,
In the CRP, my lord, the informant herself has stated that she is willing to compromise the matter,
yes. So if there is a compromise reached between the parties,
my lord. Then all the things go.
then all things will be settled. You are also, your husband,
I'm the husband, my lord.
you are also willing to compromise.
Not as by her terms and conditions. my lord.
No, compromise means it has to be mutual settlement
Yes, my lord.
on the terms and conditions of both.
Both the parties.
Regarding that, my lord, mutual settlement agreement also, there is mention in the FIR.
Earlier, my lord,
Yeah,
there was a
okay.
mutual settlement agreement. My lord,
That is, my Serial number 3, my lord, of the FIR.
Now,
My
what
lord.
should we do?
my lord, at this stage, I pray only for issuance of notice. my lord.
Okay, we'll issue notice. And At least we can call for the record of that case on the next date.
Yes, madam. Yes.
Mm. So, heard Mr. B. Gogoi.
MK Sharma.
Sorry, Mr. M.K. Sharma, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Prince Goel, praying for quashing of the affair lodged by respondent number 2. Respondent number 2, on the basis of which Fulton Bajar PS case number 278/25 was registered under section 69/318 within bracket 2, 336 within bracket 2, 337, 351 within bracket 3, 61 within bracket 2, within bracket small b /85 of BNS. Let the notice be issued to respondent number 2 by registered post, by speed post. By speed post. Within 7 days from the date of this order, returnable on 9th of December. 9th of December. Let also the case diary be called for.
Can go.
Case diary be called for. Let also the records of CRP case number
403, 2025.
403, 2025 be placed along with this case as the parties to your husband and wife.
Husband.
Parties to the dispute are husband and wife in relationship, and the said case is also pending before this court in between them, list accordingly. 9, 12.
Deeply obliged. May I read, Lordship? For 528 application, Lordship, for quashing FIR charge and entire proceeding of session case 54/21, which is pending before the additional session judge at Bilasi Para, Lordship. Lordship, at this stage, TCR may call for an notice upon the respondent number.
Heard, Mr. What is your name?
Along.
A. Alam, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Aminul Haq, praying for washing of the proceedings of sessions case number. On what ground you are seeking quashing?
So the informant which is married with another person, and she has already 3 child, and now this case is for facing the trial, she has been facing her conjugal life, Lordship. As such, she issued an oath and affidavit, Lordship. And which
For
lyrics are seek-
quashing of the entire proceedings of sessions case number 52/2021. So let the notice be issued to the respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 18th of December. Let also the scanned copy of the trial court record along with the scanned copy of the connected case diary be called for list accordingly.
May I please, Your Lordship. The 528 application, my lord, for quashing of the order 10/1/17 to till 31st October 25, my lord. Actually, this is may I see the page number 22 FIR, my lord. There occurred a riot under the Borpara PS, my lord. And the petitioner
Where is the impugned order?
impugned order, all are impugned from till 10/1/17, they were
10/1/17.
but this order is not annexed there. But main impugned
31.
order is, impugned order is, my lord, 37/22 and 29/9/22, my lord.
What is the last order? 31/10/2020.
31, we have not find that order, my lord. In the last last order, arrest to NVW was issued against the petitioners.
Where is that order?
This order we applied, but we have not find that order. And not, but next that is fixed for 11/20, 25/11, my lord. And in all,
You have not annexed neither the first order nor the last order.
we applied a very old case, my lord. 2012.
What has happened?
What has happened, my lord? There occurred a riot, my lord, page number 22.
No, why you are aggrieved? Why you have approached this?
We are aggrieved. We were a victim in this case, in this riot. We were brought to the police station at that time. And total 107, my lord, page number 22, last paragraph. Total 108 persons were picked up to the police station. Their involvement is thoroughly scrutinized with available videos and eyewitness of the public force personnel present there and found that the involvement of the following 55 persons in the rioting. And we are not within this 55%, my lord. But later on, in the charge sheet, our name was included as absconder. But we are not aware of that fact.
Now you are ready to face trial.
We are ready to face the trial.
When is the next date fixed?
Next is 25/11, my lord.
Let them appear. Though he has not impugned, he has not annexed the impugned orders.
This is pending since 2012.
Heard Mr. G. Pathak, learned counsel for the petitioner. How many petitioners are there?
36.
30?
13, 1, 3.
Learned counsel for the petitioners. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioners number 1, 2, 3, 4, 5, 6, 7, and 9, 10, 13, up to 13. Naam likhibo. Who are aggrieved by the orders dated 10/1/2017 and subsequent orders passed in GR case number 2524/2012, whereby non-bailable warrant of arrest was issued against the petitioners in the said case. Learned counsel for the petitioners were has submitted that the aforesaid GR case arose out of an incident of rioting where the present petitioners were in fact the victims. He submits that however, they came to know that the petitioners were shown as absconding accused in the charge sheet laid in the said case. He further submits that the said fact was not known to the petitioners and they never received any summons from the trial court. Stop. He also submits that all the the next date of the GR case number 2524/2012 pending before the Court of London Judicial Magistrate First Class Borpeta is fixed on yes, petitioners, plural Borpeta on 25/11/2025, and all the petitioners are willing and ready to appear before the trial court on the said date and to cooperate in the trial. However, as pending non-bailable warrant of arrest have already been issued against them, pending to Katinibu, non-bail, and he seeks some interim protection in this regard. Stop. On the other hand, an additional public prosecutor submits that since the GR case in which the non-bailable warrant of arrest have been issued is a very old pending case, and since the petitioners are ready to appear before the trial court, he does not have any objection. Stop. In view of above, this criminal petition is disposed of with a direction to the petitioners to appear before the Court of London Judicial Magistrate First Class Borpeta,
Additional CJM.
Court of London.
Additional CJM.
Why have you written Judicial Magistrate First Class?
Sorry, my lord, but in this, in orders, it is additional.
Additional Chief Judicial Magistrate Borpeta within bracket trial court in on 25/11/2025 and cooperate in the trial. So to facilitate their appearance before the state court on the said date, the operation of non-bailable warrant of arrest issued against them shall remain stayed till that date. On their appearance before the trial court, the petitioner may pray for regular bail before the said court, if so advised. This criminal petition is accordingly disposed.
Maybe this is a application your lordship for 528 of the BNSS, my lord, challenging the rejection of my prayer for Jima of the electronic items along with the bike and one car, my. In this case, my lord, what has been initially, my lord, if your lordship take up the FIR, my lord. Initial FIR was filed, Annexure 1, page 17, my lord. It was filed on 2/10/2024 by one Kopil Bakul, my. Alleging that there was a demand of 15 lakhs by some persons on the Ben Alpha organization, my lord.
Page 35.
Page 17 is the initial FIR that is relates to Simoliguri PS, my lord, which was registered as Simoliguri PS case number 24/24, my lord.
Yes.
While in this case, my lord, what happened? After registration of case, the police searched my residence and took away my mobile phones, these petitioners from my phone, Bajaj Surpa. So, your lordship, my kindly the seizure list annexure 2, page 18. There is a seizure of blue color Samsung, my lord, black color mobile phone, my lord,
light burger Vivo, then again one Bajaj Pulsar, my lord. Page 20 is a white color Tata Tigor, my lord. All along with this Simoli Buri PS, my lord. White Honda Activa. These are the seized items, my lord. Code figure. Now what happened that thereafter, after lodging of this FIR, my lord, then another FIR was logged on 16/10/2020, page 34, my lord. Annexure 3. There it is stated that your lordship, the FIR content is there, page 35, my lord. It says that they have received information from that some suspected Ben Alpha in a vehicle carrying out RESI survey of different locations, and they have named me. One Irsad Latif, me too, was picked up from Babupati. There he had during interrogation, he revealed that his accomplice Rahul Hazarika Laden and Tohirul Isel, that is also a co-accused, present petitioner, and driver Ali. All of them were working as overtime workers of the Alpha, and they were supposed to carry out abduction of 2-3 employees engaged in oil rigs at Bogota. Subsequently, the attempt was failed because the persons have left. So this case has been registered as Bogota PS case number 11 of 24, my lord. And these cases ended in charge sheet, my lord. That is on 10/11/2025. The lordship can find the charge sheet at page. It was charge sheet at case, my lord. That is page 45, my lord. In the charge sheet, what has happened, my lord? The documents, the articles which were seized in Himoliguri case were relied upon them by the IO.
Earlier case.
Earlier case that your lordship will find it. Himoliguri PS case now was relied by them, my lord. That is, your lordship may kindly see that list that articles recovered seized during investigation. These are our MR numbers as Himoliguri, man. Seized items for all our next page also. MR numbers are Himoliguri PS case. Your lordship may kindly see. Now what has happened, my lord? Then when we file an application before, then the IO has filed an application before the trial court, my lord. Trial court, my lord, for correction of the records, my lord. But the prayer was rejected, my lord.
What correction?
Correction, my lord, that your lordship will find page that we have challenged that order 27/5/2025, page 71, my lord. Page 71. Record is put up before me. You'll also get.
This is the impugned order.
Yes, well, this is one of the impugned order, my lord. Case record is put up before me on the strength of the petition dated 6/5/2005 by Tushar Desai, SDPO Nazira, seeking permission for withdrawal of charge sheet number 1 of 20, which I have told before, lordship, in connection with Bogota Nemguri PS case number so modification of seizure list with reference to Simoliguri PS, resubmission of the modified charge sheet of CS number 1 of 25. Peruse the case record, perusal of case record, disclosure cognizes already been taken in connection with Bogota Nemguri PS case number on the basis of the charge sheet number accused of the entire appearance. At this stage, permitting of withdrawal and resubmission of charge sheet, along with the modification of seizure list, is not permissible. Prayer of the IO is rejected. In the meantime, also we file an application there. You'll also make only next line of 3 mobile phones and hard as well. Identify call for a report. Then report was called for, my lord. And then report says, my lord, that is your lordship kindly. Today's fixed for April so that pays 1/7/2025, my lord. That pays 75, my lord. 1/7/2025, my lord. That is order. No, your lordship 10/6. So sorry, man. Page 74, 10/6, man. Report requisition as for considered custody of prayer has been received, put up court case. Seen the reports of IO, stating that seized articles were seized in connection with Simoliguri PS. Since that case, it registered as Bogota PS so is pertinent to mention here the reports were not seized in connection with the case. Peruse the case in view of the report, custody petition were rejected. Your lordship in the charge sheet, they relied upon those articles. They want to, because it ought to have been re-seized, my lord.
But Simoliguri PS is pending.
Pending trial, but they are not relying on seizure. They are, actually what has happened, after lodging of the FIR of Bokoto, they were supposed to re-seize the articles. IO has committed some mistake during the course of investigation. They did not seize because they are relying upon the.
But now the Jimma can be granted in the earlier case only.
No, now your lordship, earlier case also we applied, my lord. Your lordship may kindly see what has happened. That order. That page 87/2005, my lord. Page 83, my lord.
Earlier case, they said that it is seized in connect, relied on in a different case.
Yes, my lord. We are in
Therefore,
the case. Your lord, 87/2020, page 83, my lord. Today is fixed for so-and-so prayer for petition seeking so-and-so. Report requisition for considerable custody, prayer petition has been received, put up. Seen the report, I go discuss aforesaid articles were not seized in similarly PS case so-and-so. Peruse the case record, in view of the report, custody petitions is redundant, no other and petition is disposed of.
same court.
Same court, my lord. For fault of the IO, my lord, our petition has been rejected in both the cases, my lord. We are in a. Actually, my lord, they have allowed the payer of the IO to change the seizure list, name of the seizure list, actually. Correction of the seizure list. It ought to be received, that's all. Because they're relying on those documents. We are not accusing Himoliguri PS case, my lord. It was not substituted. We are accusing this other case, my lord.
Subsequent case.
That's right, yes, my lord. Yeah, apparently, it is a non-application of my code, my lord. It ought, because when they do it very well, they have to see the search sheet. The search sheet, they have categorically stated, the MR of Himoliguri were relied upon, my lord. Details has been stated also. So,
No, otherwise, whether these can be given in Jimma.
demand, because there was no confiscation, nothing was that. And these are
Yes.
electronic records, nothing has been come out, they are not relying upon those in the FSRT also. There is no statement to the effect that these documents were,
That
there was a
those
call
who
records or nothing, my lord, has been relied upon
required for trial.
for trial.
So it
On the basis of co-accused statements only we are arrested.
Lordship may call for the record, my lord, after verification.
Now
of
the question is
record,
that
Lordship may consider their plan.
the prayer of the IO ought to have been allowed for purpose of reseizing because there is a clerical mistake on the part of the IO.
no, yes, that aspect is okay. But your prayer is mainly for Jimma.
Jimma, but Jimma was never considered on merit, my lord.
Yes, it was not
Considered
considered.
merit, whether it's required or not. Simply on the ground that since there is no, since there was no seizure in connection with this case, it was rejected.
What should we do? We ask the trial court to
Your lordship,
decide.
your lordship may set aside the order and your lordship may direct the court below to rectify the mistake and pass necessary orders, my lord. Because ultimately, the prosecution will be also difficulty, my lord. If the seizures are not proved, my lord, in the eye of law, because seizure list was of Himoliguri, my lord. There's difficulty is there while prosecuting the accused person also, my lord.
But for that, we may have to go through the
Yeah,
record.
that I understand, my lord.
This may be one way out. Directing the
Yeah,
trial court to.
we'll arrange
recti-
better trial court to apply the mind, my lord, because on merit it has not been considered, my lord.
Yes, it appears.
Only on the technical ground it has been rejected.
But for that, we have to peruse the scanned copy of the case diary.
Yeah, that, your lord. Because otherwise it also hampers the prosecution also, my lord.
It
Because
will,
Because they are not relying
because
upon those documents.
IO's prayer was also
Rejected,
rejected.
my lord. Because they want that it should be reseized, my lord. Actually, there was a technical mistake on their part, my lord. It ought to have been reseized and new seizure list ought to have been prepared, but that was not done.
Heard Mr. P. Kotoki, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioners, namely 1, 2, and 3, impugning the order dated 27/5/2025. These two orders are passed in same case.
The same case in this search-sheeted case, my lord. Session case number 4 of 2025.
As well as order dated 10/6/2025, passed by learned session judge, additional session judge,
It is session judge,
Session,
and
passed
see order,
by-
session.
passed by learned session judge Sagar in sessions case number 4 within bracket SS of 2025, arising out of Bokota Nemuguri PS case number 11/2024, whereby the prayer for grant of Jimma in favor of the present petitioner of the seized items was rejected. Stop. Perusal of the records as well as records of the concerned case as well as connected case diary would be necessary for deciding this criminal petition. Hence, call for the scanned copy of the records of sessions case number
Yes.
4 within bracket SS/2025 as well as scanned copy of the case diary of Bokota Nimuburi PS case.
Bokota is what this one, the other is the. Cumulative. Bokota is, ended in charge sheet, that is session case number 4 of SS. And Thimaliguri is still pending for investigation, 24 up to 24.
Bokota will also be required.
Along with that, sir.
Scan copy of the Bokota Nimuburi PS case number 11/2024 as well as the case diary of Himulaguri PS case number
24 of 24.
24 of 24 be called for from the trial court. The registry to issue requisition for take steps for requisitioning the scan copy of first to scan copy of the trial court's record, whereas an additional public prosecutor is requested to produce the case diary of Similaguri Police Station. Similaguri PS case number
24 of 24.
24 of 24. Let this case be listed with 8th of December.
We have
Yeah.
to put it the Simulacrum.
Similaguri you have to produce other than 8th of December.
Maybe an application filed for setting aside the equivalent order 29/5/2025 and other subsequent orders in connection with POCSO case number 127 of 2024 lawsuit. After filing charge sheet, London Court below has taken cognizance and issued summons against the accused petitioner's lordship. But the petitioner could not appear because he went to Kerala to earn his livelihood lordship. So lordship kindly see annexer 3 page 28 lordship.
What is there?
The accordingly, NBWA issued against the accused petitioner lordship. And the issue of residing out of Assam for livelihood is a recorded lordship. So at that time he went to. Kerala.
When is the next date fixed?
Next date 2011 lordship.
Yes, Mr. Goswami, let him appear.
Yes.
Heard Mr.
Yeah.
R.A. Ahmed, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Shariful Islam, who is aggrieved with the order dated 8/5/2025 and subsequent orders
29/5/2025.
order dated 29/5/2025 and subsequent orders passed in POCSO case number 127/2024, whereby the trial court has issued non-bailable warrant of arrest against the petitioner. You are shown as an absconder.
Yes, lordship.
Learned counsel for the petitioner submits that in the aforesaid case, charge sheet has been laid against the petitioner under section 354-376/349/366/511/294 of IPC, read with section 4/12 of POCSO Act 2012. showing the petitioner as an absconder in the charge sheet. The petitioner submits that in the said case, initially summons were issued to the petitioner. However, as the petitioner was in Kerala for earning his livelihood, he did not receive the summons, and accordingly he could not appear before the trial court. Thereafter, by the order impugned in this case, the trial court had issued non-bailable warrant of arrest against the petitioner. The petitioner is learned counsel for the petitioner submits that the petitioner is willing and ready to appear before the trial court on the next date fixed, that is on 20/11/2025, and cooperate in trial. So, considering the submissions made by learned counsel for the petitioner regarding as well as considering the fact that the petitioner is ready to appear before the trial court and face trial, this criminal petition is disposed of with a direction to the above named petitioner to appear before the Court of Learned Special Judge Pokso, Morigaon, in Special Pokso case number 127/2024 on the next date fixed, that is on 20/11/2025, and cooperate in trial. Stop. To facilitate his appearance before the trial court, the execution of non-bailable warrant of arrest issued against him shall remain stayed till that day. Stop. On his appearance before the trial court, the petitioner may pray for any relief to which he is legally entitled to. This application is accordingly disposed.
17.
May I please lordship? But in this case, my lord, what happened, my lord, on 15/10/2025, my lord, I filed a petition before the, my lord, Learned Court below for declaring my juvenility, my lord. And accordingly, my lord, the Learned Court below was directed the joint director, my lord, of birth, my lord, and register, my lord, to appear with the documents, my lord. And he was failed to appear. Accordingly, my lord, the case was fixed 27/10/2025. 27/10/2025 also it did not appear, my lord. Again, my lord, 29, and now, my lord, fixed on 1/12/2025. My lord, now, my lord, my grievance is that, my lord, during the, my lord, inquiry period, my lord, I may be, my lord, released, because, my lord, section 9 subsection 4, my lord, says like this, my lord.
So, JJB Act. What is your age now?
16, my lord.
You are claiming to be 16
Yes, my
now,
lord. Yes, my
now.
lord. Yes, my lord. I have annexed the birth certificate also, my lord. So inquiry will be carried out, but during that period, my lord, kindly
The
section 9, my lord.
case is pending before,
Learned Court of CGM, my lord, Dorong, my lord.
yes. What is section 9? Yes,
Section 9, my lord. May I read, my lord?
yes.
When a magistrate not empowered to exercise the powers of the board under this act is of the opinion that the person alleged to have committed the offense and brought before him is a child, he shall without any delay record such opinion and forward the child immediately along with the record of such proceedings to the board having jurisdiction. 2. In case a person alleged to have committed an offense claims before a court other than a board that the person is a child or was a child on the date of commission of the offense,
or if the court itself is of the opinion that the person was a child on the date of commission of the offense, the said court shall make an inquiry that takes such evidence as may be necessary, but not an affidavit, to determine the age of such person, and shall record a finding on the matter stating the age of the person as nearly as may be. Subsection 4, my lord. In case a person under this section is required to be kept in protective custody while the person's claim of being a child is being inquired into, such person may be placed in the intervening period in a place of safety. Now, my lord, I am in jail, judicial custody, my lord.
Yes, on what basis you are claiming juvenility?
Because
You
my
have
lord,
produced some
yes, my lord,
document,
birth certificate page 11, my lord.
you have produced it before
Ye-
the,
Yes, my lord. And my lord, Aadhaar card also, my lord, birth certificate.
yes. Where is the birth certificate?
Page 11, my lord.
Yes, he cannot be kept in jail.
What has been, my lord, yes, my lord, stated, my lord. It is not stated that he has to be released, but he said he is placed in safe, in a
Safe custody
safe
or
custody.
interim bail may be
Self-
granted
yes, my lord.
That is interim,
because
He may be-
inquiry is taking time.
yes,
You are calling the joint director, he is not appearing.
on
So it
1/12 to 12.
So it has, for last 3 months, it is going on.
No, sir.
And prima facie, a document is there, birth certificate is there. You are only to examine the veracity of the birth certificate.
No, sir. That is why, my lord, it is called for, my lord, register of birth.
That may be done.
Yes.
But during that period, he should be released.
And it is not yet ascertained whether regarding the veracity of the birth certificate.
Yes, but something is there
Yes, something is there.
and
Benefit of doubt always goes to my lord accused. my lord.
we'll call for a report from CJM. In the meanwhile, we'll allow the petitioner to be released on. What is the offense?
My lord, offense, my lord, kidnapping, LS. Charge sheet has been submitted already, my lord.
He is facing trial.
Yes, my lord. My lord, it has not been committed because my lord, sessions tribunal, my lord.
And he can be produced before JJB board, my lord, then
No, but the opinion has not yet been formed by the,
not, that is difficult. And other,
let him conduct the inquiry.
yes.
Heard Mr. S.H. Sikdar, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. This application under section 528 of BNS, when have you raised the plea of juvenility?
My lord, on 15/10/2025.
You have produced the original document
Yes, my lord.
before the trial court. No. Why it was not believed?
My lord, it is, my lord, procedural, my lord. It should, it always, my lord,
Hmm.
inquired.
Impugning the order dated 29/10/2025 passed by the Court of London, Chief Judicial Magistrate Dorong Mangaldoy in PRC case number 568/2025. Arising out of Karupetia PS case number
May I
52.
intervene for a moment? for
Yes.
First, may I kindly say Annex 1, the birth certificate, my lord.
Yes.
That name is Shahjahanuddin.
Shahjahan, no.
Shahazuddin. Shahazuddin. Oh, but hey, Umaid Ali is the father.
Umaid Ali is the father.
Father.
Because he is juvenile.
Oh, he is the
That is why petition has been filed by his father.
Yes, yes. Yes, Umaid Ali is the father.
की लिख ले case number case number 52/2025 under section 140 within bracket 2/2 of BNS, whereby the trial court had remanded the son of the petitioner, who is the accused in the said case, to judicial custody instead of sending him to observation home. Your prayer is for sending him to observation home.
And my lord, any other my lord appropriate order, my lord, I have stated, my lord, or pass as other or further order, my lordship may deem fit and proper. So he may send to his my parents' custody also, my lord. It will be safe. My lord. It will be amount to give him releasing on bail, my lord, if he may be in the observation home. My lord.
No. Learned counsel for the petitioner submits that the son of the petitioner, namely Sahaz Uddin, alias Sahazuddin, who is accused of committing offense of kidnapping in the FIR lodged in connection with the said case, is a juvenile, and as he was born on 24/5/2009 and presently is only 16 years of age. He submits that the plea of he submits that when he was arrested,
He was arrested on 8/9/25.
he submits that the son of the petitioner was arrested on 8/9/2025 in connection with the aforesaid case and was sent to judicial custody. Stop. Learned counsel for the petitioner submits that thereafter charge sheet was laid in the said case, and the son of the petitioner is still detained behind the bars. He further submits that the petitioner, being the father, raised the plea of juvenility of his son before the trial court by filing an appropriate application on 15/10/2025 by producing the birth certificate of his son, wherein his date of birth has been clearly mentioned as 24/5/2029 in 2009. However, the learned Chief Judicial Magistrate initiated an inquiry and summoned the Joint Director, whom he summoned.
My lord, joint director. Kindly say last page, my lord. Register birth and date.
Whom this, where is the order?
My lord, page 23 also. Page 21, my lord. 27, 21 of page.
We will continue at two.
My lord.
Or after that, I have dictated in chamber.
Right.
For reasons mentioned in the order, the impugn order is set aside to the extent that during the intervening period of the conduct of inquiry by the trial court on the plea of juvenility, the petitioner shall be released on interim bail of rupees 30,000 with one surety of like amount to the satisfaction of learned Chief Judicial Magistrate Darong, with a condition that Putul, with a condition. With a condition that the interim bail shall continue till the completion of inquiry regarding the plea of juvenility raised by the petitioner. On completion of the inquiry, the learned CJM may pass necessary orders either by making the interim bail absolute or any other order as deemed fit and proper on the basis of inquiry conducted by the court. Partly modified, yes, okay. Partly modified.
Mm, 1/12 is a date of appearance. He has to appear regularly.
No, no.
1/12, yes, whether. Because on that date, it might be, my lord, settled, my lord, if register of guardian death. comes,
Yes,
my
on 112 you have to appear before the trial.
lord, subsequent date,
On-
on the dates, he
If
has to appear.
ultimately you are found to be juvenile,
Yes, my lord,
you will be sent to JJB.
JJB, yes, that,
The case will be sent to JJB.
on the dates, my lord, he shall appear, my lord, that. In, that will be, my lord.
That is also a difficult issue.
Because,
Suppose inquiry goes long,
yes, my lord, but, lordship,
how you can compel a
Lord.
juvenile to appear before?
yes. Both ways, my lord.
I'll mention that he will positively complete the inquiry by the next date fixed.
Lordship. Hello, bless, hello.
May I please? I will the 528 application, my lord, praying for posting of FIR, charge sheet and entire proceeding, my lord. FIR, my lord, at page 19, my lord.
Charge sheeted case,
Yes, ma'am.
what is the ground?
My lord, in this case, my lord, informant is one of the maternal and of the husband of the accused person, my lord. Both the accused person and her husband are living separately, present, my lord, having some family dispute. Although, my lord, names of the witnesses mentioned in the FIR, my lord, are not examined, my lord, and they are not made as witnesses in the search sheet, my lord.
No, during investigation, the IO is not bound by the names of the witnesses named in the FIR. He can examine other witnesses also.
Lordship.
What is your ground?
My ground is my informant is the maternal and of the accused person husband, my lord. Presently, both the accused person and her husband, my lord, living separately due to having some family dispute, my lord. To take revenge upon her, my lord, they have maternal and loss is apparent.
No, that cannot be a ground for quashing who has lost the affair.
Then, my lord, can they see the, my lord, FIR at page 19, my lord?
No, no, I will not see unless you tell me the ground on which ground you are seeking. If there is a justified ground, we will go into. There must be some ground on which you are seeking.
Initially, my lord, FIR was launched in 4 numbers of section, my lord. Later on, my lord, charge sheeted, excluded 2 sections, my lord.
That cannot be a ground for quashing. Suppose a FIR has been lodged in against a under a particular section. You come prepared. Come prepared. We'll take it up on Monday. You appear before me. Either you appear or seek. Because what you have submitted, you are unlikely to get a relief in this case. Heard Mr. H.M. Ali, learned counsel for the petitioner. He prays for listing this matter before on some other date so that he can he may go through the brief and come fully prepared before he makes his submission. The prayer is allowed. Let this matter be listed on Thursday. 20th.
Please, Lordship. Lordship, the matter may be possible for the banking.
Why?
My senior is coming.
Okay.
Item 27. Second time application, Lordship. Scan copy of the teacher.
Update is not available, Lordship, because it is
Scan copy was called for.
scan copy received, but it is not up to date because Lordship, oh, sorry, 23/7, honey. It's a record to apna agot GSA to because on earlier occasion, Lordship, the rejected bail application, it is 23/7/2025. And till then, 5 witnesses have been examined. Same status is there, Lordship.
Those 5 witnesses.
Lordship, the 5 witnesses are also there. And Lordship, last was date of order.
So on what ground yours?
Subsequent, another witness has been examined. It was on Lordship on August 25.
What is the case?
Basic. So, informant Lordship, was the FIR, we agreed that Lordship some tablet, Yaba tablet was recovered from the possession of this person. And according to section 22C is Lordship.
22C is there.
Yes,
Commercial quality.
What is your ground?
ground. One is the long interpretation of the petitioner since the.
How long you are detained?
Since July 24, 1st of July 24.
How much time?
4 months. Next is that Lordship.
1 year, 4 months is not long.
Yes. I'm saying also. And second is that Lordship, they have examined 6 witnesses, including the informant. Even the search, Caesar witnesses also examined. The Malkhana inspector was also examined. All this Lordship indicates, all this evidence adduced by those witnesses doesn't Lordship indicates that this petitioner is guilty of that offense, Lordship. Kindly Lordship have a look at the evidence of adduced by this. All 6 witnesses, Lordship. After he has Lordship.
Total 9 witnesses are there.
9 witnesses after the rejecting.
Nobody has named you.
Only the informant. And in my first application also, Lordship, our contention is that the informant and this petitioner has a long Lordship enmity was there.
No,
Because of-
that
yeah,
we will
yeah,
not consider.
Facts of the case. So this informant along with some other person also try to grab the land of this petitioner. This is the case. One civil case is also going on. That is different issue, Lordship, but I'm saying.
How will you overcome 37?
On the first occasion also, Lordship, it is question of 37. So Lordship may come to my petition at page 11. 37 also I have explained.
New ground
37.
also has to
New
be-
ground is also there also.
What new ground?
Because earlier rejected, Lordship.
Earlier rejected, Lordship, that doesn't mean that this petitioner has no right to approach again, Lordship, because this, they have.
You
applied
cannot raise the similar ground on which
Similar ground, I'm not saying similar ground. Lordship, kindly have a look my petition, page 11. Page 11.
or the last witness deposition is
Yes.
there.
After rejecting my first application, Lordship, another.
Yes, what is your submission?
At the fake end of the trial, Lordship, only 9 witnesses are there.
Okay, then we'll,
Can it be a Lordship submission? That all
Moreover,
witnesses
Lordship,
examine, Lordship?
no, let him submit, let him.
Lordship,
If we are
Lordship,
hearing it, then
Lordship,
let him
Lordship,
submit.
okay.
You want me to take up this matter today?
Let's have the up-to-date copy of the decision.
Yes, let the.
After
Heard,
this, Lordship,
heard. Mr. J. Kolita, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned the additional public prosecutor, who submits that though the scanned copy has been received, however, same is not up to date, as only the testimony of 5 witnesses are there on record. How many witnesses have it?
Six. Out of 9, she was there.
5 witnesses have been there on record. Let the an up-to-date status report of the trial of NDPS case number.
So this special case number 572.
Of NDPS special case number
572 of 24.
572 of 2024 be called for from the trial court. Let also the scanned copy of deposition of any further witnesses beyond PW5 who might have been examined be also called for from the trial court. When?
Lordship, on 27.
Let this matter be listed on 27th of November.
Obliged.
May I please, Your Lordship? Okay, this is a regular bail application, my lord. Petitioner was arrested 16/8/25, that on to the 90 days, my lord. Page 11 is the FIR, my lord.
90 days,
90 days, my lord. Charge sheeted matter, my lord.
charge sheeted.
Yes.
Oxometer.
Approximately, PCR received, my lord.
Respondent is also.
Victim has been examined.
No, my lord. Just, my lord, next date was yesterday, but subsequent date in the, he could not uploaded, my lord.
What is your case?
My lord. I'd like to first read out the FIR, my lord, page 11.
No, what is your case? Tell me the brief.
Submit about my case, my lord. I want to read out the FIR. In the informant respectfully begs to the state that since 1.5 years, the accused person doing acting of love with my daughter, namely so and so.
Amount, subject to the satisfaction of the trial court with following conditions. Trial conditions. Trial conditions then. This bail application is accordingly disposed.
I'm obliged.
29. He did not available.
May I please, Your Lordship? CD was for Lordship, last 3 occasions CD is not, has not received Lordship.
But
And
they
this is the case of Satgaon police station.
are on interim law.
Your Honor, we'll make absolute interim.
And the photo is not adopted, they have just.
You are on interim. You have appeared before the investigating officer. In BA, they are on interim.
It is written here, no? I don't know why, Lordship, but it is in the petition, it is stated that interim granted.
Chief has put in the bill.
Okay. Who are you?
Gopal Sona, that's it.
This is POCSO is also there, Lord.
But POCSO is not adopted, Lordship. They have just inserted the question.
You are on bail. Heard Miss A.C. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, who submits that the some more time may be granted for production of the case diary. You have taken steps?
We have taken 3 types, on regarding service lordship,
No.
or regarding sending message to the IO lordship. We have give signal on 3 occasions.
Regarding service, we have taken steps, lordship.
But we have not received any service report, lordship.
Okay, let them take one more chance. You intimate the court about the service report as well as case diary also. You will remain on interim.
Lordship.
Learned counsel for the petitioner submits that this is for the third time the prosecution side has failed to produce the case diary in spite of specific directions to do same. Stop. It also appears from office note dated 31/10/2025 that service report in respect of notice issued to respondent number 2 has not been received, though the petitioner has taken steps for the same on 7/10/2025 itself. Considering the above facts, learned additional public prosecutor is requested to take information regarding fate of the notice issued to respondent number 2 from the officer in charge of jurisdictional police station. Which police station? Within bracket Satgaon police station. And let this court know about the same on the next date fixed. One more chance is granted to the prosecution side to produce the case diary on the next date fixed. When
25th, lordship.
let this case be listed on 25th of November. The interim order shall continue.
If I is at page 10, I was arrested on 1/7/25. I was the driver of the truck.
Pending investigation.
No, but I think charge sheet, right? Charge sheet submitted. But one thing that if I can say that way, but going through the record, I had the privilege of going through the record from my friend. What I find, my lord, the 47 notice and the 48 notice signatures have been given by. It's true, but in the note also they have written that it was made understand to me in my mother's language. But I have a specific allegation. Those were not submitted. But these were just they through force they put us the signature, and in the note they have written in the bottom that it was informed to me in my mother's language. I've gone through the record. That is there, Your Lordship. In the record, Your Lordship will find. Your Lordship may go through the record and Your Lordship may find it out.
In which language?
It is in the stereotype in English, but it has been in the mother tongue, they have said. Only thing in note, Your Lordship will find in the record.
No, why to disbelieve? And how to verify your allegation.
Because that also there is a question, because I have signed in English. That is, my signature is in English, I've seen that. But, and the time when it was given to me, because Caesar is of 30th and 17, whether it was provided to me 2 hours prior to the forwarding me to the magistrate, those things will come into, nothing has been there. Nothing has been laid down over there. And I rely upon how far it is there, the recent judgment of the Supreme Court in para 56. That it should be 2 hours prior to, and should be.
No, for relying on this judgment, you have to first make submission that it was not.
My statement is there that they have not produced me the copy itself. There is there, that I have made a statement.
But
about
that they have submitted.
that they have obtained a signature. What I am saying, when a person is arrested before the police, they give it, they forcefully take us our signatures.
Is there any statement to that effect?
But
That forceful signatures were obtained?
no, not that way, but we have said that at para 9, my lord. That it was not submitted, has not been communicated, who was arrested by the police. And in the note at 47 notice, your lordship will find, bottom they have given note. It was informed to me in my mother's tongue. After the signature, they have.
So why to disbelieve them?
They could have put it in why in the English? There is a stereotype copy. They could have put it in the mother tongue itself. Why in English? That is also the question before the prosecution, madam. Why in English? Why not in the mother tongue? Why not in Assamese? If the judgment says that it should be in the mother tongue, the language that I understand, whether they have asked me, what was my mother tongue? What was my language? Which language do I understand? I am behind the
Whether
curve.
you have raised objection that the language in which they
I
are
have said
communicating,
that Paradigm has not been communicated. That itself shows, because
but that has been belied.
the copy itself shows prima facie. Bottom they have said. Why they have said that it has been informed, and when I have signed in English, your lordship will find in the note. They could have written above my signature. Why in the note they have said it has been informed to me in my mother tongue?
Because they have done so.
My allegation is that they have not done it.
Which para you are relying?
Para 9, I have said they have not communicated. And in the judgment, madam, Supreme Court judgment, para 56, your lordship will find. Supreme Court judgment, para 56. Roman 2, then Roman 3 also. It can be done orally. And at least 2 hours prior to the production of the arrest. Roman 3. This is the recent judgment. It was delivered on, my lord.
But you have not taken that plea that it was not.
Prima facie, I'm showing it from the documents. They have written, if I could have signed it in English, what was the necessity for them to give it in the note? That itself, so there is something fishy over there, my lord. That they have not made me understand. They have not done it, and I have said they have not given me the copy.
Your submission is that it was not
Communicated to
you in your mother tongue.
mother tongue.
What is your mother tongue?
My lord, Bengali. The language I understand,
What language you understand?
Bengali, that was as my instruction goes from my friend. And the note your lordship will find from the record. Bottom they have given that. It was on 6 November 2025.
This is the only ground.
This can be the only ground, because the charge sheet has been filed, my investigation is over.
Yes, Mr.
As per I have seen section 47 and 48 lordship, grounds has been communicated because he has written in English lordship, his signature, and it is in English only lordship. And it is also that stated that they had explained it in his mother tongue. It may be lordship, because he has
note in the bottom, that paper.
In the last line, Lord. In handwriting, Lord.
And your handwriting is very good.
My lord. I am a driver and that is the handwriting, my lord. Your lordship will find. How much it is correct also, my lord.
You are denying that.
My instruction goes, by. Your lordship can understand that language, the way the Asmat Ali is written down, my lord. It shows that he is an educated and not an illiterate person. But the next 48 notice to some relative, your lordship will find the language, way of signature.
No, is it your plea that you don't understand English?
My lord, my plea, I cannot say that, but it was not made because my lord, that is a stereotype language written down in English. But it was not communicated to me, or it was not educated to me through that my mother tongue. Because just by informing, this is you are what to do. Grounds of arrest has to be communicated and educated to me, that I have a right to go for something against this alleged arrest. The
Where it is written that it is to be in his mother tongue?
Well, para 56, Roman 2.
There is no mention about
The
mother
grounds of arrest must be communicated in the writing to the arrest, in writing to the arrestee in the language she
understands.
Well, I don't understand that. It was, it was not.
So there has to be plea in your bail application that you don't understand English language.
Para 9 have said it was not communicated to me, because the next one your lordship will find Roman 3, in case where the arresting person is unable to communicate the grounds of arrest in writing or soon after arrest, it be so done orally. The said ground be communicated in writing within reasonable time. That what my lord, the Supreme Court, the apex court is saying communicated. Communicated is a big concept where it should be include educated. I should understand what will be the consequence to be done by me in case of arrest. Just by giving a stereotype paper and getting my signature is not communicated.
Heard Mr. P.K. Roy Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Asmat Ali, who has been detained behind the bars in connection with Howley PS case number 78/2025 under section 22C/22C of the NDPS Act 1985. The aforesaid case was registered on filing of an FIR. Where is the FIR?
FIR starts at page 10.
Filing of an FIR.
Relevant portion, page 13.
By one Shri Gopal Bora, SI of police, inter alia alleging that on receipt of an information to receive through reliable sources that a goods carrier mini truck bearing registration number AS25 FC 398687 would be coming from Howley to Guwahati and would be carrying huge quantity of narcotic substance, a police team was constituted and a Naka checking was arrived Naka checking was arranged. During Naka checking, it was found that the aforesaid truck, within bracket truck bearing registration number AS25 FC3987, was diverted towards parking area, and the driver was trying to park the vehicle there. Stop. The police team apprehended him, and the driver was identified as Asmat Ali, within bracket present petitioner. On search of the said truck, total 26,000 Yaba tablet weighing about 2,600 grams were recovered therefrom. Learned counsel for the petitioner has submitted that the petitioner has approached this court seeking bail in this case, mainly on the ground of violation of his fundamental right guaranteed under Article 22(1) and statutory right guaranteed under Section 47 of the BNSS, inasmuch as the grounds of arrest were not communicated to him in. Where is the statement?
Yeah, 9, madam.
In the language he understands.
Para 6, page 6, we have said in writing in language which he understands. In para 9 also I have stated that. The language I understand.
But you have not mentioned what language you understand.
That is there. What language but they have stated that it is the mother tongue. But they have also not stated what is my mother tongue and what language they have informed me, whether it is in Assamese or in Bengali. It is their investigation also, which is there a lot of fault. It is not that they are clean sheet everywhere. A person who is arrested, well, the situation has grown up that way.
Learned counsel for the petitioner has submitted that the petitioner, though can put his signatures in English language, understands only Bengali language, and the notice under Section 47 of BNSS was served to him, which is in English language. Therefore, he submits that grounds of arrest may not be regarded as communicated to him in the spirit in which it is required to be communicated. He further submits that in support of his submission, he has cited a ruling of the Apex Court in the case of Mihir Rajesh Shah versus State of Maharashtra and another within bracket criminal appeal number 2195/2025, wherein the Apex Court has observed that the grounds of arrest must be communicated in writing to the arrestee in the language he or she understands. Stop. Learned counsel for the petitioner further submits that the notice under section 47 was not served to him prior to 2 hours of the time when he was produced before the magistrate. This plea you have taken? No. Oral submission. Which is also a requirement of the law as laid down by the apex court in the aforesaid judgment. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the petitioner on the ground that the quantity of contraband seized in this case is of commercial quantity, and therefore embargo of section 37 of the NDPS Act is 1985 is applicable to this case. He submits that on perusal of the notice furnished to the petitioner under section 47 of the BNSS, it is apparent that in the said notice, the accusation made against the present petitioner and the facts necessitating his arrest has been detailed elaborately. Stop. He submits that though the notice under section 47 of BNSS, which was served on the present petitioner, has been written in English language. The petitioner himself has put his signature thereon in English language. However,
actually, one more thing, he has not, written is not there. He has not stated that before the trial court, that he has not understood it.
yes,
There is no plea, written plea, Lord.
he further submits that nowhere in the bail application as well as before the magistrate before whom the petitioner was produced, he took the plea that he understands only English, only Bengali language. He further submits that no plea has been taken before the trial magistrate, before the magistrate before whom he was produced, that he failed to understand the content of the notice served on him under section 47 of the BNSS. Further, he also submits that in the body of the notice itself, it has been clearly stated that the grounds of arrest were explained to the arrestee in his mother tongue. Hence, he submits that the plea raised by the learned counsel for the petitioner is not acceptable plea, and therefore he prays for dismissing the bail application. I have gone through the I have considered the submissions made by learned counsel for both sides and have gone through the scanned copy of the case records, which was requisitioned in connection with this case. Wednesday. बाकी part रखी दो. Heard so and so. Let this case be listed for delivery of orders on 20/11/2020.
May it please your lordship. My lord, the petitioner he was arrested on 5/8/2025, my lord. It is now 102 days today, my lord. Charge sheet has been submitted, my lord. He is a 59-year-old person, my lord. He was serving. There is absolutely, my lord, there is no blemish in his service career. It is for the first time, my lord, this kind of allegation has come up against him, my lord.
What allegations?
My lord, the POCSO Act, my lord.
The
My lord,
victim has appeared.
my lord, here, no, my lord, here. Regarding service report, my lord, I prefer short accommodation, my lord. In today morning also, I have talked to my lord, she concerned my lord, regarding the service, my lord. And I prefer 3 days, my lord, for service.
Let them verify. Let them verify. Heard Mr. M.K. Das, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for a short accommodation to let this court know regarding the fate of the notice issued to respondent number 2. Stop. The prayer is allowed. Let this matter be listed on 21st,
My lord,
Can it be on, my lord, 20, my lord?
20, okay, 20.
Deeply obliged.
may I please, your lordship?
32, my lord, notice served, my lord. Amicus may be appointed.
Heard Mr. K. Thakur, learned counsel for the petitioner. Also heard any amicus present in the court. Also heard Mr. P. Thakur, learned additional public prosecutor, who submits that notice issued to respondent number 2 has been duly served. Since no one has appeared for respondent number 2, this court is inclined to appoint Shri N. Mahajan as amicus curiae to defend the cause of respondent number 2 in this case.
Lordship, respondent number 2 is the mother, lordship, mother of the victim. Respondent number 3 is the informant, lordship. We had taken for both, lordship.
Respondent number. Respondent number 3. Who Jagat 3 Gurjeev. The petitioner shall take steps. Petitioner shall furnish copy of bail application along with annexures to the to Mr. Mahajan within 2 days from the date of this order. Let the
Lordship, can it be fixed on lordship? Because CD is also available.
21.
Yes, sir.
Let this matter be listed on 21st.
Deeply obliged.
Right, this is a POCSO section 8 of the lordship. Charge sheet has already been submitted. Record has been called for received lordship and amicus was appointed in this case lordship. Equity is behind the bar for
last 70 days from 6/9. It is a case of section 8. Lordship, FIR is at page 11, Lordship, translated copy, Lordship. The only allegation here is my son and hold my son's hand immediately and take away my son behind the corner of the shop and commit leap is badly. This is the only allegation, Lordship, and open the jeep. It on the order framing chart. I would like to draw your attention, Lordship, to take to page 32 first, Lordship.
Here, charge sheet has been framed. Charge sheet has been filed.
We have raised objection, that's why I'm coming, Lordship. Just, I would like request Lordship to take page 32, Lordship, to go to page 32, Lordship. Page 32, Lordship.
Yes.
May I read, it is filed on 18th April 2016, Lordship, with a contention that जो प्राय 5 বছর পূর্বে 1 নম্বৰ পদকীয়জনৰ লগত মোৰ বিয়া হয় বিয়াৰ পিছৰে পৰা 1 নম্বৰ পদকীয়জনে বাকি পদকীয়সকলৰ কুপৰামৰ্শ মতে মোক নানা ধৰণৰ মানসিক শাৰীৰিক অত্যাচাৰ কৰি টকা পইচা দাবী কৰি গালিগালাজ কৰে 50,000 টকা দাবী কৰি মোক খেদিয়াই দিয়ে 17/3/16 তাৰিখে. This was the first allegation, Lordship. We have faced the trial on that case, including my parents under 319. That case was disposed, Lordship, page 34. Judgment was delivered. I got acquittal.
Okay.
On 7/7/2025, Lordship.
In which case,
This earlier, this first FIR case, Lordship.
PRC case number?
This was GR case 55116.
Okay, thereafter,
Thereafter, Lordship, during that period, I have also faced 125 proceeding, Lordship. I made draw your kind attention, Lordship, on page 53 and 54, Lordship.
okay.
I have
What,
given 2 pages where I am regularly paying maintenance on 5/12/2022, that is before filing of the second FIR. Petitioner is present, OPS deposited rupees sum of 4,200. Same amount may be allowed. Then 5/1/2023, Lordship, 4,200 deposited. Petition has been collected. Then on 6/2/23, deposited 4,000 that has been collected.
okay, you are paying, accepted.
During the filing of the second FIR, Lordship,
When
the
second
impugned
FIR?
FIR at
Where-
page
where?
13. This FIR was registered on 17/1/2023. Again, the same set of facts, now this time 1 lakh demand. I was deserted from the matrimonial on 17/1/2023. Neither in the maintenance, while she is taking maintenance prior to filing of this FIR and after filing of this FIR. Nowhere, neither in evidence that earlier matter was settled, she has restarted the conjugal life, come to my house. Nowhere. The maintenance orders, Lordship, at page 54,
No,
5/1/23,
where,
6/2/23.
after the acquittal,
After the, no, during pendency of that trial, second FIR comes, Lordship.
no, in this first FIR, what was the plea? Whether she was still staying with you?
No, not at all. She was all along 16th, she left my matrimonial home. She was living with her parents. That case trial continued up to 2025, 7/7/25 judgment was delivered.
On 17, since 17/3/2016.
She is living separate.
And
She
in-
has filed one maintenance case, she is receiving regularly maintenance. As directed by the court, with some areas we are paying here and there, the area part. But subsequently, suddenly she came up with this FIR. Subsequent FIR on 2023. Without any mention that yes, there was a previous FIR, there was any compromise, restarting of conjugal life, nothing else.
and maintenance is, you're paying still.
Yes, Lord.
She's living separately since?
Since 2016, Lord.
Yes, Mr. Goswami.
We have raised this issue before the trial court also, Lordship. We have
Why
already
trial
commented.
court frame charges?
Not considered. We have nothing to say more on that line, Lordship. We have pointed out everything that yes, trial is going on, we are facing the trial.
That's why I come before this honorable court, lordship. This is a clear abuse of process, lordship.
Second FIR, my lord, is 17/1/2023. Again, the receipt of the this maintenance amount, my lord, 5/1/62/23.
5/1/23 prior to
6/2/23.
FIR, 6/2/23 after the FIR.
After the FIR 6/2/23.
Then again on code 3/23.
Only thing, my lord, my learned senior submitted that whether they have, after that, they have started their conjugal life. Thereafter,
Okay.
again, that is only the issue. My lord.
That is vital,
That is vital. my lord.
that any, whether any of the witnesses have stated anything.
No.
In one,
Judgment we
in,
have, till judgment I have annexed here with lordship. No, none of the witnesses.
no, in
Even
the,
receipt
in
of
the,
the maintenance shows, lordship.
in the second FIR.
No.
In the
No,
second
no,
case.
I have not got the
the-
copy,
the-
lordship, of this 151.
During investigation, is there any statement that after the acquittal
I
in the,
don't have that.
that
So
is
151
read?
copies are not. there.
Yes, as it also filed. my lord. That is the in the FIR.
When is the next date fixed?
6/12, lordship. My humble request, lordship, till next date or it may be stayed, lordship. It is clear because evidence, summons have been issued to witnesses, lordship.
Yes, Mr. Gusa.
Uh, Seems to be very peculiar, my lord. because,
Yes. Heard Mr. S.K.
my lord,
Poddar.
on 7th.
In the
July
second
2000
FIR, there is no mention about when they started
Yes. well,
living
that is-
again.
That is the crucial point. Let me kindly say page 48, my lord. That is on the 7th of July, the other case has been disposed of. 7th of July 2025. It's after filing of the second FIR.
Okay. Heard Mr. S.K. Poddar, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, namely Saikhul Islam, praying for quashing of the proceedings of PRC case number 789/2023 pending before the Court of London, Judicial Magistrate First Class Bilasipara under section 498A of Indian Penal Code. Learned counsel for the petitioner has submitted that the victim, no, the respondent number 2 who is the wife of the present petitioner had lodged an FIR earlier on 18/4/2016 against the present petitioner and his family members in alleging that the petitioner and her family members have subjected the respondent number 2 to torture and demanded dowry from her and drove her out of her matrimonial home on 17/3/2016. Learned counsel for the petitioner submits that on the basis of the said FIR, GR case number 551/2016 was registered. And after completion of the investigation, charge sheet was laid against the accused persons, including the present petitioner. He further submits that, where is the judgment of that case?
From page 34 onward. Okay.
He further submits that the said GR case number 551/2016 was disposed of by the trial court by passing by the trial court, that is the Court of Learned Sub-Divisional Judicial Magistrate M. Bilasipara on 7/7/2025. So by the aforesaid judgment, the petitioner and her family members were all acquitted of the offense under section 498 of Indian Penal Code. He further submits that during the pendency of the aforesaid GR case, the respondent number 2 had also initiated a proceeding under section 125 CRPC, claiming monthly maintenance from the present petitioner. He submits that in the aforesaid proceeding, the petitioner has been regularly paying the monthly maintenance to the respondent number 2. Stop. He further submits that during the pendency of the aforesaid GR case number 551/2016, the respondent number 2 had lodged another FIR on 17/1/2023 before the officer in charge of Bilasipara Police Station, leveling similar accusation of subjecting the respondent number 2 to torture and demand of dowry of 1 lakh rupees. However, in the said FIR, there is no whisper made about lodging of an earlier FIR by the respondent number 2. He further submits that there is also no mention about as to when did the respondent number 2 return back to the matrimonial home and started living again along with the petitioner. He further submits that this is a material suppression made by the respondent number 2 in the FIR, and the said plea was raised by the petitioner before the trial court also. However, same was not taken into consideration. He further submits that from the materials available before this court, it is apparent that by lodging a subsequent FIR, suppressing therein, suppressing the fact of lodging of the earlier FIR and pendency of GR case number 551 is a abuse of the process of court. This subsequent FIR is true or false?
Totally, but he is not with us. Since 16, she is living separately. We are paying maintenance as per our capacity with some.
Learned
people
counsel
here.
for the petitioner has further submits that the accusation made against the petitioner and his family member in the subsequent FIR dated 17/1/2023 on the basis of charge sheet, on the basis of which charge sheet was laid in GR case number 36/2023 are absolutely false. In as much as the respondent number 2 is living separately from the petitioner since the year 2016.
Second wife, no?
Stop. And the petitioner is staying with his second wife. Stop. The contentions raised by learned counsel for the petitioners needs to be examined. Hence, let this hand copy of the GR case number, a scan copy of the PRC case number 789/2023, along with the scan copy of the connected case diary, be called for from the Court of Learned Judicial Magistrate First Class Bilasipara. Let also notice be issued to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by speed post within 7 days from the date of this order, returnable on 18th of December 2025. So considering the contentions raised by the learned counsel for the petitioner and submissions made by him as discussed in the foregoing paragraphs, further proceeding of PRC case number PRC case number 789/2023 pending before the Court of Learned Judicial Magistrate First Class Bilasipara shall remain stayed till next returnable date.
Public.
Very please, Your Lord. The regular bail application, my lord, as on today, my lord, 84 days in jail, my. FIR was filed page 28, my. And on source information, the informant who happens to be the Inspector of Police of Crime Branch, my lord, apprehended the accused near Grandson office located at Beltola Wireless Mine with 21 numbers of bundles of 500 denomination, totaling about 8,54,000.
Now, what is the period now you have undergone?
84 days. Man. Actually, my lord, he was arrested on 23/8. FIR is saying he was produced before the magistrate, not a CGM on 24/8. Arrested on 23/8. My lord, the section is started 178 and 179 BLS. But actually, at best, this case would come within the ambit of section 180. Because they were not, my lord, caught red-handed while manufacturing or circulating or, my lord, using the same as genuine.
180 is possessing.
180 is possessing, yes. 180 says, my lord, whoever has in his possession any forged or counterfeit coins.
What is the punishment?
7 years.
And what is the punishment under 178, 179?
Life, for life and
90 days.
yes, 90 days. my lord.
Yes, otherwise they have completed 84 days.
But 84 days, but this is my lord, considering the economic of the total my lord, 8,54,000, my lord, total 1708 numbers of my lord, all 500 denominations recovered from his possession at that point of time, my lord. And those along with him, my lord, there are other persons also there in syndicate, my lord. They are in fact involved in manufacturing, selling, transporting and everything, my lord. And my lord, regarding that, some other accused persons not yet arrested, my lord. Police is in charge of those accused persons. And from his possession, my lord, all these
my lord.
No possession, he is admitting.
At that point of time, my lord, he is, my lord, about to sell, for selling at that point, waiting in that place, my lord. At that point of time, my lord, on the basis of source information, police apprehended him.
No, but any evidence regarding selling, manufacturing.
My lord, regarding that, my lord, some of it, though, my lord, though printing machines, police in search, my lord, right now, my lord. Regarding other one, accused
Now,
person.
for last 89 days, what have you collected?
My lord, regarding, well, from his possession, those, my lord, huge number of, my lord.
That is
accepted, my
admitted.
lord. Considering that, my lord, regarding other accused persons who are the part of that organized crime, my lord, those persons, my lord.
Otherwise, after 6 days, you,
My lord, considering the type of offense what he has committed, my lord, these are, my lord, serious economic offenses, fake currency, my lord. So considering that aspect, my lord, length of detention also cannot be a ground for releasing bail. my lord.
otherwise, after 6 days, you will be unable to detain him.
It's true, my lord.
90 days.
Get instruction, my lord, whether police will, my lord, within this, police can find such.
Page 29, order to learn passenger, we approve the learn passengers.
What instruction you want to take? You may take. What instruction will you take?
Period of 6 days, my lord, whether you can file such it or not.
Now, suppose within this period, if they lodge in case charge sheet, it has to be under 180 only because no material is there. Within 6 days, they will be able to collect evidence. You can take instructions. I'll give them 2 to 3 days time.
Monday, my lord.
Yes, considering, my lord, the gravity of the offense and
Invest-
from his possession, those huge amount of, my lord, fake currency notes were recovered.
My lord, I was 5 days in police custody, thoroughly interrogated. On 29/8, my lord. there was
Yeah. Heard, Mr. K.R. Ahmed, F.K.R. Ahmed, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Jahidul Ali, alias Jahidul Ali, who has been detained behind the bars since 24/8/2025, within bracket for last 84 days. Learned on the accusation that huge quantity of counterfeit notes were recovered from his possession. Learned counsel for the petitioner submits that though this case has been registered under section 178/179 of the BNSS, however, no ingredient of said offenses are there. He admits that there may be ingredient of section 180 of BNSS in this case, as the counterfeit notes were only found from possession of the present petitioner. He further submits that the maximum punishment provided for an offense under section 180 of BNSS is 7 years only. And in such a case, he would have got bail much earlier. Stop. On the other hand, learned additional public prosecutor has submitted that he may be granted some time for seeking instructions from the IO investigating officer in view of the fact that huge quantity of counterfeit notes were recovered from the possession of the present petitioner. The prayer is allowed. Wednesday, let this case be listed.
Tuesday, my lord.
No. Wednesday, your probability will be more of getting bail. Let this matter be listed again on 20th. let the case diary, which is available, be retained till next day.
Charge sheet at charge was frame 5 months, my lord, whole family members are behind the bar. Your lordship will find that is petition number, your lordship will see 70 as petition number 1, father. 2, mother is 60 years. Number 3 is the person who is husband of the wife, my lord, that victim.
What is the offense?
Offense 302, my lord. 304B, alternative 304A, my lord. 304. Satisfied. Now your lordship will find FIR is page 40.
Charge sheeted case.
Charge sheet, charge also framed.
Charge frame under 302.
Yes. Now, charge frame under both alternative, but your lordship will find. What was it?
304 and 302.
Yes.
দুটা দেখো।
2 sections, man. Your lordship, AB, what are kindly see, madam. Your lordship, what are page 21. Sorry, page 21, yes. Your lordship, idea AB, my lord. When they appeared, then they were taken to custody, my lord. As per this court order, my lord, they have appeared.
Where is the?
Yes, your lordship, page 22, your lordship. Page 22, 23 is the operative part. NBW was issued, my lord. Again, that we have come, your lordship. So for 15 days, your lordship was pleased to stay this NBW. And directing them to appear. Accordingly, prior to the expired 15 days, they have appeared. 15 days, my lord, expires on 19, and they appeared on 13/6/25. My prayer is, my lord, this stage, your lordship, everything is completed, my lord. Like that, they will, my lord, offer in the trial, my lord, whatever is there. And whole family members.
Where is the FIR?
Yes. FIR is page 14, 1-4. Look at total 7% name is the high. 6 and 7 are juvenile. 6 and 7. Accused number says 7, so they are not before lordship, only up to 5. Marriage took place 9 years ago.
How she was killed?
Actually, in fact, my lord, we have explained also here, your lordship, something there with the husband, my lord, something maybe there, but her, in fact, to our information, actually, she was having some problem with her parents, my lord. Yes.
No, what is the allegation? How she was killed?
Then in the pond, my lord, along with the child.
Child is also dead.
Yes, child is also.
No, how it was distinguished that whether it is a case of murder or suicide?
They also consider 304B also and 302 also, man. They are also not clear, man. Which offense they have committed, man. And then I'm on.
It is within 7 years of the
no,
marriage.
No, 9 years, after 9 years. Marriage, 9 years ago, marriage took place, man. The FIR itself it is there, man, third line. Because she will become 9 years ago.
For 9.
So 7 years, not within 7 years, prior, above 7 years.
What is your submission?
My submission, my lord, merit also I find, my lord, cause of death, whether, my lord, she was killed or she was that thrown to a pond, that is matter of evidence, my lord, it will come, my lord.
No, what is there in the charge sheet?
No, charge sheet they have stated, my lord, charge sheet they have implicated.
What they have
They had
stated?
implicated. At this stage,
No,
my
no,
question.
how they have implicated? What they have stated?
No, in my case, my husband was in Kerala at that very point of time. They were not present. brother-in-law there lives differently, my lord. She had some problem with her father, my lord, that we have stated in our petition also, my lord. Paragraph 9. And that's what was page 35, no?
No, I want to understand just one thing. Her dead body was found in the pond along with the child. How the IO found out that it was a case of
Yeah,
suicide?
that is why, my lord, there is an order, my lord. As per order, the 23-10-25, my lord, this honorable court has directed to see the peruse of the CD is required, my lord. So along with now, my lord, as per the office note, the CD has come to see the witnesses, my lord.
So in the case diary,
Yeah, in the case diary, 161 statements I have flag marked, my lord. There some amount of torture and demand of dowry is there against these petitioners, my lord. So my lord, as per that's what in the search sheet, my lord. So it was as per the IO, my lord, that 304B would be, my lord, a case against them, my lord. That is what written in the search sheet, my lord. After good.
B of the 34.
34.
okay, what is your submission?
My submission, my lord, that is a very pathetic, my lord. See, believing it to be without going to 302, my lord. 304B.
Now, whether custodial detention is necessary
5 months, my
for
lord.
trial.
Trial, my lord.
Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr. M. Hussain, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioners, namely 1, 2, 3, 4, and 5, who are detained behind the bars since 13/6/2025, within bracket, for last more than 5 months, in connection with session within bracket TI, case number 26/2025, corresponding to Uloni PS case number 52/2023. Learned counsel for the petitioner has submitted that the petitioners, prior to approaching before this court by filing the instant bail application, had approached this court by filing an anticipatory bail application when the trial court had issued non-bailable warrant of arrest against them. He further submits that in the said case was disposed of on 4/6/2025 by this court in AB case number 1125/2025, whereby the non-bailable warrant issued against the petitioners was stayed and the petitioners were directed to appear before the trial court on the next date fixed. So accordingly, he submits the learned senior counsel further submits that accordingly, the petitioners appeared before the trial court and prayed for bail. However, their prayer was rejected and they were remanded to custody. And since 13/6/2025, they have been languishing before behind the bars. He submits that in the instant case, though accusation against the petitioners has been made of causing death of the petitioner, causing death of the victim woman and her child due to torture. However, the trial court has, in addition to, in alternative, has framed charges. No, trial court has framed charges under section 302 of Indian Penal Code and in alternative under section 304B of the Indian Penal Code. Learned Senior Counsel further submits that the entire family members has been put behind the bars, and therefore it has become difficult on their part to properly defend the case. He submits that the petitioners are ready to cooperate in the trial and abide by any condition imposed by this court while granting bail to them. On the other hand, learned counsel for the learned additional public prosecutor has vehemently opposed the grant of bail to the petitioners on the ground that a mother and her child had to end their life because of the torture perpetrated by the present petitioners. He submits that there are sufficient materials in the records which indicates that the petitioners had subjected the victim woman to torture, leading to which caused her death. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials on record. Stop. Without commenting on merit of this case, this court is of considered opinion that since the petitioners have surrendered before the trial court in pursuant to the directions given by this court, and since for last 5 months, entire family is behind the bars, it would be naturally difficult on their part to properly defend themselves in the trial which they are facing by remaining in custody. Since the investigation has been completed and the petitioners are ready to cooperate in trial, this court is of considered opinion that if they abide by the condition imposed by this court while granting bail to them, there may not be any necessity of further custodial detention for fair completion of the trial of sessions within bracket T1 case number 26/2025. Stop. For reasons stated herein above, the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of
Additional session judge number 3, Nagaon.
learned additional session judge number 3, Nagaon, with following conditions, trial conditions. This bail application is accordingly disposed. Bail के हिसाब से मत
item six, S4, item 22.
How much time will you take?
Around 15 minutes. Sir.
We don't have 15 minutes today.
Well, Honorable Chiefs, the urgent fixing of the case is there. The trial court is very much reluctant to give any order, dates for further hearing of the case. That is why the trial court has fixed the date by tomorrow for hearing argument. The case is pending since
Okay, what is your case?
April 25.
Try to finish it off within 10 minutes,
You will see.
within 5 minutes.
It is a very, to me, it is a very simple petition, Your Lordships. We have filed a petition before the landed trial court under the garb of section 311 of CRPC, now converted into 348 of BNSS, praying for passing an order re-examining the victim girl who has not been cross-examined on material particulars but by the learned counsel engaged in connection with the case. Subsequently,
You want re-examination of victim girl?
before delving into the different aspect of the case, Your Honor, Your Lordship, I would like to invite
Where is
Your
the
Honor,
where is the impugn order?
if impugn ordering
Page 29, A, my lord.
page 29. Page 29.
29 is the impugn order.
29, A, my lord. There's two.
29.
Yes, please read the impugn order. Please read.
The accused has filed petition number 843 of 24 under section 311 CRPC, requesting a recall of PW1 in order to cross-examine her father. It is stated in the petition that the accused was falsely implicated in this case because the accused is from Assam and the victim is from Bihar, and that while they were living on land on the same campus on numerous occasions, they fought among themselves, and as a result of the animosity that had developed between them, this false case was filed against the accused. It is also said that the accused informed his conducting counsel to take appropriate defense, but it could not be done due to certain unintended errors, which now needs to be explained by cross-examination of the victim. I have heard both sides. Learned counsel standing for the accused argued that the accused ought not to be penalized for the mistake of his engaged counsel, and that whatever errors made by his counsel must be addressed through a re-cross-examination of the PW, the victim. Learned defense counsel, while making submission, relied on the Honorable Supreme Court decision Rajendra Prasad versus Narcotic Cell, true officer, reported in AR 1999 Supreme Court 2292, as well as the Honorable Guwahati High Court decision John Singh Inti Kathar versus State of Assam and others, reported in Monu in 2023. On the other hand, learned special public prosecutor argued that this is an old pending case. The victim was only about 4 years old at the time of the LA.
This petitioner is behind the bar for last 53 days, my lord. He is the, my lord, manager of the prime accused, my lord. Prime accused was granted bail by this honorable court on 42 days, my lord. Though my earlier bail petition was rejected by this honorable court, my lord. This is regarding, my lord, illegal mining at the Umrangso mine.
His diary is there.
Can you take up this matter? My lord, 83 days, my lord. Lordship, on Monday, my lord.
Monday.
May I submit?
Let him go through.
All the accused, my lord, including my.
You are manager.
I am manager, my lord. All of them were granted bail. Earlier when my bail.
Let him go through the case diary. We'll take it up on Monday.
Monday, perhaps.
Monday at 2 p.m. You have not gone through, Mr. Bhotakur.
Yes. For a second, I will show your lordship.
No, no.
Because-
First, I have to decide whether because we don't have time,
Lordship.
whether to hear this matter or not.
No, my lord, your lordship may kindly fix it Monday. my lord.
Okay, heard Mr. J. Laskar, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. Due to learned additional public prosecutor submits that he needs some time to go through the case diary, which is available before the trial court. Let this matter be listed on 17th at 2 p.m.
But that bench is available, my lord. I think division bench is there.
No, somebody will be available.
It was already rejected by your lordship. That's why, my lord, I am pressing you. In the end event, my lord, you will be behind the. And then, my lord, my lordship may peruse the record, case diary, my lord, and thereafter may consider my position, either rejected or accepted.
No, on Monday. Let us see. Yes,
My lord, I think 42 to 47, my lord, we invested the same case diary. Can I come on Tuesday?
42 to 47.
Same case diary has come, my lord, there will be retained till Tuesday. Monday, there will be a lot of cases. my lord.
Tuesday also we, okay, on Tuesday.
Regarding 41, my lord, similar prayer. So the third time.
You may have to stand
Lordship.
again for the fourth time if you insist on your own dates. If you don't allow the registry to manage the dates, if bar goes on insisting on dates, at the end of the day, there is every likelihood that you have to stand like this on a.
Tuesday also, my lord.
If you are agreeable to that, then Tuesday.
My lord, I don't know, 40 my lord. Yeah, my lord.
Okay, Tuesday.
My lord, in respect to item number 49, it was fixed for interim relief today, my lord, upon service of the trustee. However, the trustee service was unable to do the respondent private.
What is your prayer?
Stay on the entire criminal proceeding, my lord. Senior counsel, Mr. Kamal Agarwal is appearing in this matter, my lord. Can it be fixed on 1st December? The trustee service has not been concluded.
1st December, due to paucity. What is item number?
49, ma'am.
49, due to paucity of time, this matter could not be taken up for hearing. Let this matter be listed on 1st of December.
An interim prayer may be considered on that day.
No.
My lord, in the previous order, it has been mentioned that the interim prayer would have been.
Nothing more than that.
Last-
Then your prayer which you are mentioning will be rejected.
there's
Then
another
it will be
prayer.
left over,
My lord, registered post, I was supposed to.
left over. Matter left.
For 50 lordship, there is urgency lordship. Person is behind the bar lordship. Item number 50, there is a delay. That's
Other-
why lordship. on
Other
Monday, lordship.
matters, I request the bar to pray before registry. Registry will accommodate all of you.
Your lordship, only 55 number item, there is the extension of order. That may.
Extension will be automatically granted when the matter is not taken up.